Yes,
Praying a lordship leave to file this application without a certified copy, lordship.
Group 6.
Group 6, lordship, service matter.
When was the order passed and when did you apply?
2012, 2023, lordship.
When did you apply for certificate?
Applied, lordship. Lordship, didn't apply, lordship.
Sorry, you apply first, then come and take the.
Okay. With leave of Justice Chatterjee, my lord, may I mention before your lordship, it's an assigned matter assigned to your lordship sitting with Honorable Majesty's value money, my lord. It's a group 6 matter arising out of a selection.
Mention when her ladyship comes back. Yes, call the list.
Item number 1, my lord. Yesterday I have mentioned that our appearance was recorded, my lord, for Union of India.
I am for the petitioner, my lord, in this matter. Serial 1.
Give the names.
অর্ডারটাও দেওয়া আছে, এটাও দেওয়া আছে।
Asu. By reason of a typographical error. Heading for
Union of India, respondent number 6.
One,
2, my junior is there. 1 and
জনের নাম দিয়েছে কি? By reason of a typographical error in the cost title of the order dated 15 January 20, the name of the learned advocate was not incorporated. Later in the cost title of the order dated such and such, the name of the learned advocate appearing for the respondent number 6 was not incorporated. Stop. Office is directed to make necessary correction by incorporating the name of the learned advocate, who appeared on behalf of the respondent number 6 in the cost title. এটার পরেরটা দিতে হবে না। অফিস ইজ ডিরেক্টেড টু এফেক্ট নেসেসারি কারেকশন।
Good.
ঠিক আছে।
The petitioner's advocate is there.
Well, I am online, my lord, for the petition.
ও কি আছে ওনাদের নাম দিয়ে দিই।
Grateful, my lord.
My lord, I am appearing on behalf of Phatik Chandra Das. He is on road jam, so I am praying for not today.
2 weeks. Yes.
I appear for the status.
Yes.
Lordship, on behalf of Mr. Devangan Bhattacharya, I am praying for a passover, Lordship. He is on his way, Lordship.
Passover cannot be there. Monday week করে দাও। You have instructions and everything.
But basically, the application, what I find is simply praying for a preponement of the hearing and nothing otherwise. Because what has been done already, AO has been filed on my behalf. They have not yet, perhaps from the record, it appears they have not filed the reply till date.
Not filed
And
the
they have
reply
stayed.
yet.
I do not have any instruction, Lordship.
Monday week করে দাও। Yes, next.
I'm grateful, Lordship.
Why these applications are filed, I don't understand.
My lord, item number 4 and 5, I am for the applicant, my lord. I am led by Mr. Kolava, so I am praying for a short passover, my lord.
My lord, kindly keep it Friday week. Next Friday is a holiday because my assigned matters are going on before special bench.
Friday week, yes.
My lord.
Friday week আমার চলছে তো।
Friday week, yes.
Next Friday is a holiday.
Yes, Friday week করে দাও।
May we have the liberty, Miller, to file an informal paperwork, Miller, within this time?
I appear for the other side. I'm opposing the appeal, the maintainability of the appeal.
Friday week. Yes. Next.
Please, may I please, your lordship?
Six, my lord, I am appearing for the Mr. G and I, my lord. I am led by Mr. G and I, my lord, for the Union of India, my lord.
My lord, this appeal arising out of an order passed by my lord, just there is an application for condonation of delay. My lord, there is a delay of a few days. I have
43 days,
explained.
my lord.
You have served.
Yes, sir. Yes, my learned friend is appearing on behalf of the respondents, all the respondents.
Only state respondents are there.
No, not Union of India. It's only Union of India. And staff selection commission, no, they, I think he
My
is
lord, kindly see the my order dated, my lord, 22 August 2023, my lord, which is passed by Honorable Justice Lapita Banerjee, my lord. After consideration.
My lord, there is a delay of 49 days to file this appeal, my lord. I have explained the cause of delay in paragraph 3 onwards on my application, my lord. My lord, I am praying for condonation of delay and hear out the appeal, my lord. The innocuous prayer is that, my lord, the authority concerned rejected my candidature on the ground of unfitness of extensive tenure corpuses, my lord, which is not at all a ground as mentioned in the medical guideline. Although, my lord, I have obtained another opinion from the Murshidabad Medical College. The doctor opined that I have no tenure corpus
That cannot
at
help
present.
you.
My lord, I know that. That's why I pray before the honorable court for a direction upon an independent.
Why independent, sir? So that you are saying that this disease is not a disease
Yes.
for declaring unfit.
Yes, yes.
Have you incorporated the guidelines here?
My lord, I have the guideline. It is voluminous. That's why I crave leave to file this at the time of hearing, my lord. My lord, this is the guideline I am handing over.
Where is your section 5 application?
My lord, section 5 application, my lord, can 2. Sorry, my lord, can 1. Can 1.
Paragraph?
Paragraph 3 onwards. Four to 8, I have explained the reason as to why.
Yes, are you opposing the section 5?
No, my lord. No, my lord. 49 days delay only.
Affidavit of service filed by the appellant be kept on record. Stop. Upon hearing the learned advocates appearing for the respective parties and considering the averments made in the application for condonation of delay, we are satisfied with the explanation given towards the delay in preferring the present appeal. Stop. Accordingly, such delay is condoned and the application being can such and such is disposed of. Stop. In, list the appeal along with the application for appropriate order for further first February. Stop. The learned advocate appearing for the respondents is directed to avail necessary instruction.
Yes, my lord.
In the
Okay.
meantime,
Oblige, your lordship, grateful to lordship. Much obliged.
here no affidavit of service.
Yes, I have a benefit of service, man.
Come back with that instruction whether that disease is within the unfit.
We have a guideline, my lord.
You have the
Yes,
guide?
my lord.
Yes, next.
Take the right.
Lord, item number 7, I am appearing on behalf of the petitioners.
First time it has come. It has come for the first time.
Yes, sir.
Who is your other service is complete?
Handed over the service.
State is the
No,
party.
Union of India.
তাহলে কি করবে? There are what delay application is there?
No, my lord. No delay. My lord, order is passed on 21st December 2023.
Yes. Who appears for Union of India?
My lord, in the writ petition, Miss Sharda Shah and what should I say? Sharda Shah and Indrani Dotto, yes. না আমি বলেছি in writ petition বলেছি।
Affidavit of service filed by the appellant be kept on record. Stop. No one appears today on behalf of the respondents.
Yes. আমি আপনার আদার সাইড
To give কি বলি action করে to give a further opportunity to the respondents to appear, comma, the matter stands adjourned, release the matter for further consideration on
মানডে তো
আজকে হচ্ছে কত তারিখ?
মানে can it be 24th?
Come on 31st.
মানে
ও তাহলে ঠিক আছে।
কি হলো?
Yes,
Please.
yes, where is the order?
মানে that order is annexed in my writ.
You have your instructions today.
No, first time this is appearing, my lord, I have to take instruction. Then my lord, I come back on
Affidavit of service filed by the appellant be kept on record.
instruction না নিয়ে কি করে হয়?
Part B Sarkar, learned advocate appearing for the appellant. ওনার নাম Miss learned advocate appearing for all the respondents.
All the respondents, তাই তো?
Praise for leave to avail
এই একটা কাগজ
the
দাও তো।
instruction. Stop. List the matter for further consideration. The daily supplementary list of this court on 31st. Yes.
31st লসিত এই নামটা দিয়ে দিবেন। নাম দিয়েছিস? নাম্বার 7 ইন্দ্রাণী
Milord, this is
That's
my
enough.
application. It's a restoration application, Milord. No. This is can 5, Milord.
Can 5.
Can 5 is my application, Milord.
Upon hearing the
Milord, there is one peculiar aspect of this, which I think I ought to point out to your lordship. I have annexed the list of the day on which the matter was dismissed for default.
This 9.
And in the list, which I have annexed to my application, at page 19, it's item number 74.
you are appearing for all the respondents.
My lord. There's only one respondent, my lord. MB Commercial.
An application is mentioned which is already disposed of. So I'm asking for a restoration of that. Your lordship sees item number 74, page 19. The appeal is FA 143. Then below that,
Can that be
IA
a
number
ground?
can 1 2018, old number that.
Can that be a ground? If other applications are not given, your advocate will not keep track of the appeal.
Milord,
The
this is
ridiculous-
wrongly appeared.
Why wrongly appeared?
because it's been disposed of already.
Maybe, but the appeal has not been disposed of.
Appeal has not
Can
been.
that be a ground taken by the learned advocate? That as the application was wrong, but the appeal was right, I did not appear. It's a ridiculous explanation.
No, I'm just saying I'm not asking for a
That
restoration.
is a ridiculous explanation given. Ashok, upon hearing the learned advocates, have you filed your affidavit of service? Yes, show us. Affidavit of service filed by the appellants be kept on records. Upon stop, the present application has been preferred. না তুমি ওই ক্যান নাম্বারটা দিয়ে দেবে, অ্যাপিল দিয়ে ক্যান নাম্বারটা ক্যান 5 5টা দিয়ে দেবে, দিয়ে অর্ডারটা করো ভিডিও সার্ভিস as filed be kept on record. Stop upon hearing the learned advocates appearing for the respective parties and upon considering the averments made in the application, we are satisfied with the explanation given towards the absence of the learned advocate of the appellants before the court on 3rd September 2018. Which order you are seeking?
It's at page 20. Page 20. 20th September.
Sorry, the explanation with the explanation towards the absence of the learned advocate for the appellants before the court on we did together 20th September 2023, when the appeal and the connected applications were dismissed for default. In view thereof, the order dated 20th September 2023 is recalled and the appeal together with the connected applications are restored.
Pending connected.
Together with the pending connected applications are restored to their original respective original number and file. The application being can such and such is accordingly disposed of.
Grateful to your lordship.
Which application has been disposed of earlier?
That is what I was pointing out. Not as an explanation for my absence. Merely
Can
to-
3, can 1.
Can 1.
So
Can 4 is pending. Can 4 is pending.
yes, no, not that one.
My lord, Can 4 is an application by them. One of the appellants had died. So that is also pending.
That is pending. One of them has been disposed of.
Which one?
That is, your lordship sees page 19. At the bottom, IA number CAN 1 of 2018, old number CAN 1 of 1995. Page 19, item number 74, my lord.
Devi Bangul has died,
Yes.
and her legal heirs are already on record.
Yes, my lord. That's my substitution application.
Which application has been disposed of?
The first one, my lord. Your lordship sees just below the appeal, IA number CAN 1 of 2018, old CAN number CAN 1 of 1995, within brackets, that has been disposed of. I'm not offering it as an explanation.
By which order it was disposed of?
Your lordship gives me a moment. I'm not offering it as an explanation, merely saying it's disposed of.
That is stated in your restoration
Yes.
application.
It is. That's what I'm pointing out. So it doesn't have to be restored, it's disposed of.
Which is the date of the order?
I, yes. Three and 4 are pending. হ্যাঁ একটা ওদের একটা আমাদের ঠিক আছে
238 লিস্টে নেই ও।
না নেই, ওটা আগে দিতে আপনি।
Can one of 18 disposed of on which date, sir?
Milord, we haven't got that date,
Oh,
but it is disposed of.
আপনি নামটা কি করতে
কোনটা?
চারেরটা ডিসপোজ অফ হয়ে যাবে
Can 5 হলো তো।
চারেরটা যে রেকর্ড অলরেডি
Can 5 is this application.
সার্ভিস করেছে কিনা জানি না।
লিগালি আসো
One is pending. It is pending.
Who has expired? Who has expired?
Pushpa Devi Bangar has expired.
And who are her heirs?
The heirs are her son.
Have you served that copy upon them? Application?
For this, that has been served. I filed the affidavit of service.
My lord, her heirs are already on record. 2, 3, and 4 are the heirs.
They are already on record. It's not a substitution application.
You can dispose
Yes,
of that
yes, my
application
lord. I have
also.
no objection, my lord. Can 4 can also
Yes,
be
then
disposed of.
your lordship disposed of that matter also.
নিয়ে নাও সাহেবের থেকে ক্যান কোনটা তুমি দেখে বলে দাও।
আচ্ছা ক্যান 4 অফ 2020. আচ্ছা by preparing this application the petitioner has sought for an order to get the name of Pushpa Devi Bangur expunged from the cost title of the memorandum of appeal. So it is submitted on behalf of the appellant that the Pushpa appellant number 1, Pushpa Devi Bangur, has expired on
My lord, 1st July 2023.
on 1st July 2020.
My lord, I'm sorry, my lord, I'll give the date. That is the date of knowledge. That is 25th April 2023.
Already on record.
25th
April.
25th
April 2023.
25.
April 2022.
23.
23.
ওটা কি ঠিক টাইম উইদিন লিমিটেশন ফাইল করে সাবস্টিটিউশন
No, no, আমাদের এই application ই তো আছে।
আচ্ছা লার্নার
এই application ই বলা আছে।
responded did not
দেখো, কবে মারা গেলেন?
in view thereof let the name of the appellant number 1 being Srimati Pushpa Devi Bangur be expunged from the cost title of the memorandum. ঠিক আছে office is to take
Heirs are already on
necessary
record. Heirs are already on record.
record. হ্যাঁ
My lord, can 3 is my application. Your lordship had heard this application. Commissioner for appointment of commissioner in terms of the direction of the Honorable Supreme Court just to assess the mean profit because the suit was filed in August 1996. The learned trial court decreed the suit. My lord,
There was a direction for affidavits. You people have
yes,
exchanged.
yes, my lord, your lordship had heard the matter, my lord. Your lordship said come up with a common name, my lord.
Yes, what
So-
we have agreed to a name.
Yes, yes, we had agreed, yes.
Yes, we have. Mr. Shonendu Ghosh, Bar at Law.
Your lordship will kindly see your lordship's order. My lord, this is at page, the order dated, my lord, 19th April 2023. Matter was fixed.
Where are the affidavits?
My lord, affidavits are complete in the matter, my lord. All complete. Your lordship had kept it on 25th April for naming of the person, my lord. But unfortunately, the appellant died.
Yes.
So matter was directed to go out of the list.
When did we hear it?
My lord,
25th April.
yes, your lordship had
25th
kept it
April,
on 25th April,
2023.
but could not be taken up because unfortunately, your lordship's previous order at 19th of 91.
Wait করে দাও ক্যান 3টা
হুম।
কোথায়?
19 ফটোটা দেখলে বললেন যে সময় গেল।
এটা তোমার
এটা ফাইল করতে হবে? It's the affidavit of service in which application? For substitution জন্য।
My lord, prayer is at page 8, my lord, and the order, relevant order portion is at page 62 of the Honorable Supreme Court, my lord.
At page 64 is the relevant portion, second last paragraph, my lord.
कोई जा खोती नहीं.
Now, who is the, you have agreed to the name of a
Yes,
particular
Yes,
advocate.
we have. We have.
Your lordship had, my lord, directed that agree on a name, or otherwise your lordship will, my lord.
Dispose of near note. Page 64 এ ডিরেকশন
আমার brief টা তো
ওটা ক্যান নাম্বারটা বসিয়ে দাও
করা থাকবে.
দুটো clarify করছি. Now the earlier commissioner has two
No,
special
there
officers
was no commissioner
There
before
was no
this.
commissioner, my lord.
Yet to be.
special officers were appointed.
My lord, no, not in this matter.
Yes, you were asked to deposit the amount, no?
No, they were asked to
Yeah,
deposit.
we
the
are
amount
depositing
before
the amount.
Registrar.
The amount is, those are the terms of the stay and we are depositing.
No, we find an initial order that one Mr. Justice Nadira Bathilia's order that was way back decade to the.
Yes, my lord, in terms of that order, my lord, that is at page 56. My lord, that order is at page 60. 60.
Yeah, just a moment.
They were directed to deposit occupational charge from the date of granting of stay. So we went up in Supreme Court, my lord, before the Honorable Supreme Court with a prayer that the deposit ought to have been from the date of filing of the suit, because now there's a decree in our favor. The Honorable Supreme Court increased the amount and directed that you go before the Honorable High Court and a commissioner will be appointed to assess this from the date of filing of the suit, my lord. We had made this application, my lord.
And what happened to the special officer who was earlier appointed?
My lord, there was no special officer subject to correction, my lord.
See the order dated 11th of June 2018.
11th of June 2018 এখানে আছে.
My lord, 11th June. No, 11th June. And
60 million.
oh, yes, your lordship. Now this, my lord, money which was the special joining and shall deposit in a short-term interest-bearing fixed
Supreme Court
deposit.
does not say that that special officer has been discharged.
My lord, this is with regard to the quantum which they had deposited from the date of granting of stay.
You understand
My lord,
that?
my lord.
But
No,
that
it has
special
no.
officer has not
No,
been
no,
discharged.
no, my lord. Now, this is my application is for appointment of referee, my lord, to calculate the mean profit from 96. This they have not been.
Can numberটা বসিয়ে নিও।
You are the respondent here.
My lord,
Plaintiff respondent.
plaintiff respondent.
Yes, it has been decreed against us.
The suit instituted by the plaintiff respondent herein, paying for decree of recovery of first possession, was decreed by the learned trial court, and a decree of mean pocket in respect of Schedule 1 property was also passed, directing the judgment debtor to pay rupees 50,000 per month from the date of filing of the suit till the date of recovery of possession, and a direction was given for making inquiry for the determination of the amount of mean profit by appointing a commission. ঠিক আছে? The dispute forming the basis of the suit went up to the Honorable Apex Court. Honorable Apex Court এখানে বলে Had the Honorable Apex Court
by an order dated
The Honorable Apex Court by an order dated
15 July 2019.
15th July
15 July
15 July 2019.
2019.
directed as follows. পড়ে ওই দুটো প্যারাগ্রাফ।
এইটা
হ্যাঁ।
Directed as follows. বলে এই page 54. I can see it. Sorry.
My lord, page 63, last paragraph. Page 63, last paragraph onwards. Perhaps the answer is there, my lord. The Supreme Court had directed that this money will be deposited before the registrar.
No, we are not concerned with that. We are only for the commissioner
My lord.
appointment. Page 64, last দুটো প্যারাগ্রাফ। তারপরে
The court reveals that an application under Order 20 Rule 10 of the Code has also been filed before the learned trial court. However, during course of hearing, the parties agreed the name of a person for being appointed as a
in terms of this
as a commissioner to determine the account of means profit in terms of the order of the learned trial court and the Honorable Apex Court. In view of such facts and circumstances, in such contexts,
give the name of the commissioner. Name of the commissioner.
Mr. Swarnendu Ghosh, my lord. We will write it down and give it.
Such and such Ghosh is appointed as a commissioner with instruction to make an inquiry and determine the amount of means profit. Who shall make necessary inquiry and determine the amount of means profit in terms of the order of the in terms of
So he shall trial court আর proceeding কোথায় pending? Suit to dispose.
Disposed of হলো mean profit
So that commissioner will report to the trial court.
Yes, my lord.
My lord, because now the appeal is before your lordship, my lord. At the time of final, that is what the Honorable Supreme Court has held. Towards the end of the appeal, your lordship will. My lord, may I just place that paragraph? Page 64, my lord.
About direction.
We request my lord, we clarify, second last paragraph. We clarify that the commissioner shall inquire into the mean profits, independently influenced by the directions which have been passed in the above term. The above directions shall necessarily abide by the final result of the inquiry or such direction as may be issued by the High Court while hearing the first appeal. My lord, when your lordship is disposing the first appeal, it is my humble prayer, my lord, that can also be disposed with the appeal, my lord. Because otherwise, again, it will go back to the trial court, my lord. And then that has to be adjudicated.
Your paper books and everything.
Everything is ready. Appeal is ready for hearing, my
আমাদের অ্যাকাউন্ট করতে বলেনি
বলে দিয়েছে তো
মানে ইস্যু কনসিকুয়েন্সিয়াল ডাইরেক্টলি
My lord, the mean profits may be assessed certainly, but no decree to be passed until the disposal of the appeal.
Once the matter is being finally heard, my lord, decided, my lord,
Then
humble prayer, my lord, that the report may be adjudicated by a lordship, my lord, because it will be bring the matter to a complete end, my lord. Otherwise, again, going back to the trial court, there will be another round of litigation.
Commissioner, who shall make necessary inquiry and determine the amount of main profit in terms of the degree passed by the learned trial court,
as well as in terms of the order passed by the Honorable Apex Court. Passed in civil appeal number, passed in civil appeal number 524 of 2019, bracket arising out of SLT within bracket C number 6161 of 2000.
You have to hand over all the papers to the commissioner.
Yes, my lord. Yes, that is to be done.
Plaintiff respondents shall hand over all the relevant documents to the commissioner so as to enable him to make such inquiry and determination.
My lord, the remuneration may be shared. We had decided, we had fixed, my lord, 25,000. My lord, 25 subject.
Assigned. Has this matter been assigned?
Yes, to your lordship.
Yes, my lord.
একশো সাথে ট্রায়াল কোর্টের পাওয়ারটা আমরা এক্সারসাইজ করছি।
Well, only the remuneration may be, my lord, of the learned commissioner. It may be fixed, my lord. Remuneration of the learned commissioner, we have agreed 25,000 per sitting, subject to your lordship's consideration, my lord, will be shared by both the parties equally.
Yes, I have no objection to that. That is correct.
The remuneration of the commissioner is assessed at rupees 25,000 per sitting, which shall be shared by both the parties equal.
We have been informed that paper books have already been filed and the appeal is ready. ওইটা পরে দিন because the parties would be at liberty to mention the method of final.
We have been informed that the paper book has already been filed in this matter and the matter is ready for hearing. Because the party would be at liberty to mention the matter for enlistment upon notice to the others.
My lord, grateful. Only one thing for lordship's clarity. Your lordship will kindly see page 46, my lord. Since your lordship, my lord, the order of the trial court, but how this thing had happened, my lord. One paragraph I will just place. Page 46. The plaintiff does get a decree for recovery of khas possession of the suit premises in schedule 1 of the plaint. Or page 46, my lord, of this.
Yes, we have seen that.
My lord, grateful.
You have got it.
No, they are not. Then they are in
No,
occupation.
they are still in occupation.
They are paying the charges as per the direction of the Honorable Supreme Court.
Yes.
On the returnable date, the commissioner will file a report to the law.
How much time will be required by the commissioner?
My lord, 6 months, my lord. Because pleadings have to be completed, my lord, then evidence. We'll have to get a valuer, my lord. They might contradict, my lord. Or your lordship fixes any time if required, my lord, with liberty. If extension is required, we'll come, my lord, because
Commissioner has to report back to us.
my lord. But we will have to give evidence, my lord.
Yes, you will have to. So it
My
will take just to the parties would be at liberty to mention. শুধু দিয়ে দাও না হিয়ারিং ওটা তাহলে দেওয়ার দরকার নেই পেপার বুক ইজ রেডি ফর বিন প্রফিটের তো প্রসিডিং আলাদা তো ওটাতে তো সাক্ষী যেটা হবে then we are not we are recording his appearance. You hand over all the pleadings, liberty to mention শুধু দিয়ে
My lord.
That is better.
that will be better because if we call the appeal hearing it is better if the mean profit is determined.
Very well.
নামটা দিয়ে দেবে নামটা দিয়ে
But only one thing, then will it be a lordship's pleasure, my lord, to make it 6 months, my lord?
Come and mention
Very
for us.
Yes, that's better.
Give the pleadings, let him enter into reference. In the meantime, you will be conducting. Whenever it is finished, you come back and tell us.
My lord.
Your name
too.
My lord.
You, last you.
You have given different names.
My lord, that is
You
the you have it. Yes.
Whether he likes it or not.
No, is the disposed of. Is the commissioner is not required to report back to us in the meantime? What is
My lord,
as by you have agreed by consent the appointment,
my lord.
so he has to report back to us only after determination of
My
the
lord.
That's right. After he has assessed the main profits, not until then.
We are giving you liberty to mention as and
Yes,
when-
that is correct, madam. That is
yes, disposed of.
yes, madam. All.
3 application যা আছে সব disposed.
Grateful.
এই যে affidavit of
এক একটা already disposed of.
তিনটেই হয়ে গেল হ্যাঁ হ্যাঁ
Can one has already been disposed of?
Yes,
I think that was the appropriate order.
that has been disposed of earlier. Affidavit of service.
ফাইলটা একটু চেক আপ করে নিও না, যদি দেখো রেকর্ড পেয়ে যাও বলে দেবে, ওই ডিরেকশনটা দিয়ে দেবেন, registry is directed to record the disposal of the application being such and such. তার আগে দেবে records reveal that that application has been disposed. আমায় দাও দেখি করে দিই আগে। what are the application, what is can 1? Can 5 is the restoration, disposed of.
My lord.
Can 4 is the substitution,
My lord.
Yes.
disposed of.
My lord.
What is can 3?
Can 3 was for appointment of special officer for the commission.
Can 3 disposed of.
Disposed of,
And
yes.
can 1 must have been disposed of.
Yes, that is right. Can 1 has been disposed of. But what is that?
Can 1 is for the injunction.
My lord,
Can 1
yes.
was for the interim
Must
order.
have
একদম প্রথমে যাও, নাদিরা পাঠিয়ে দিয়ে দাও।
It is 2388.
Two, three, eight.
995 of 2018.
I think
I'm sure.
Can 1 টা বের করো তো এখান থেকে। Can 1 old number 1995. You must be having a copy, na? Can 1,
My lord,
you have a
presently I don't have it, my lord, because
you have a copy?
I too do not have this. I only know it has been disposed of.
No, we cannot record, na?
My lord,
Without seeing,
I
how can
understand.
we record? What was that application about?
Yes, yes. I will
What was
just
that
check.
application about?
my lord, can we check and come back, my lord, because it will be
ছেড়ে দাও, ওই ক্যান 1 টাকে রেখে দাও, যেরকম আছে থাকবে। পেয়েছো ক্যান 1? তাহলে ক্যান 1 টা রিকুইজিশন করে নিও। Yes, next matter.
grateful.
तीन चार पाँच, तीन चार पाँच, तीनटेই dispose. Yes, next.
I am for the petition with Mr. Bhandara. Today I have some difficulties. My learned friend also some
So,
difficulties.
Mr. Chatterjee, why the matter was mentioned?
I am sorry, extremely sorry.
And your junior was
Yes, yes, I,
thrice. He said that I have mentioned in thrice. You are not putting it in.
I, I'm extremely sorry, my lord. Kindly excuse me, my lord.
How can we excuse Mr. Chatterjee?
But
You please talk with your junior.
I have
No,
talked.
please talk with
I have talked with me. No, I
that just now you have to hear. It is so urgent.
dear lordship, kindly take it up on Monday, my lord.
After we
I
have
no
ex
difficulty.
we have, it is not a question of Monday or Tuesday, Mr. Chatterjee. We have to control our court. If
Definitely,
the
my lord.
advocate say that I
I'm not
will
going
upgrade
any
and then I
argument,
will
lord.
pray for adjournment.
But I'm not going to any argument. I'm not going to anywhere. Your lordship, kindly take it up, my lord. Kindly today is like about.
Not today. Where?
Yes, sir, but only another thing, my lord. Can it be taken up on Monday week?
Sorry,
Yes,
Mr.
sir, very,
Please do not embarrass us.
very,
Mr.
very well. Let it be on Monday. But may I file my reply, my lord?
It will not. What for reply?
On that date, on that.
Well, reply, my lord, it was earlier direction by Justice Velumoni, my lord.
Very good. You have given copies to your other side.
Yes, but yes, sir. Perhaps it has been.
Perhaps. See, sir, how do you mention these matters? You are not a very junior in the matter.
But in that event, today I shall definitely I am again, sir.
এটাকে কবে নিই আমরা? ফ্রাইডে তো, তাহলে নেক্সট ফ্রাইডে দিয়ে দেবে। ফ্রাইডে উইক হয়ে যাবে, নেক্সট ফ্রাইডে তো ছুটি।
Your Lordship, Friday is Republic Day.
What?
না ফ্রাইডেতে দিচ্ছি না, ফ্রাইডে উইক বলছি।
Yes, next.
I'm grateful. মানে may I file my
Your
reply?
Lordship.
On that date you file.
That this is my application, Miller. I have also filed a connection application, Miller, being can number 1 of 2023. Miller, the crux of this matter is
Where is
Miller,
that can, Mr. Vasu?
into the mention করেছে। এইটা আছে এই ক্যানটা ফাইল।
That is not in the list, na?
না আছে তো, 10-এ।
করছে
24 এর or 23 এর application.
23, 24.
Your application is 24 or 23?
Can 24, 1 of 2024.
24. You said 23, that is why we are.
23 is the WPCD number. 175.
Yes, Mr. Basu.
Yes. Milord, we have questioned a proprietary.
What is that can about?
Milord, can Milord, it is a subsequent development, Milord, after filing of this writ petition. Milord, what happened, Milord, in this case, Milord, in a very nutshell, Milord, is this, Milord, that 8 February to 14 February 1997, Milord, there was a advertisement, Milord.
Mr. Basu, we cannot hear without that application then, because you are saying it is subsequent,
Subsequent to that.
development.
The subsequent
Have you
development.
served it upon them?
Ministry, Milord, it was served upon the ministry.
Give a copy to your friend, because you will be relying upon that, no?
Achha, copy. Milord, this was served on, Milord, to Mrs. Amrita Pandey, Milord, it was Anamika received, Milord. Amrita Pandey, Milord, we have received.
You were not given notional benefits
Yes,
from the
Milord.
date of
Yes,
your
yes,
alleged engagement.
yes.
This is the grievance.
It is the grievance, and
now
thereafter.
your pension have been disbursed.
No, pension, Milord, I am yet to retire. Today, Milord,
You are yet to
yes. In the immediate, what happened, the central government, Milord, has issued a notification which, Milord, acknowledges, Milord, the appointees who were appointed, Milord, on the basis of our advertisement, which was prior to 2004. And I am similarly circumstances. And, Milord, that is why I am saying that on the one hand, you say that the pension.
Then what is this application? You have annexed that memo.
Yes, I have said that we have given certain benefits, but that is why I say that similar, Milord, the other service benefits should be given to me. Otherwise, Milord.
Your Lordship, learned ASG is appearing in this matter. He has requested if it could be fixed in the first week of February, other than 5th, Your Lordship. He shall argue and the matter could be disposed of.
Madam, we are handling a court. It cannot be every time it will be, we have to fix it as and when directed.
As Your Lordship pleases.
Why do you repeat this prayer? It embarrasses us. You know what system
My
is
apology,
being-
my apology, Your Lordship.
It embarrasses us. Na? If the
Next time,
say that first you fix the date, fix the time, then you come and say today we are constitutional matters are pending. We will not appear. Fix it another day. This embarrasses us.
My lord.
Let the application you have given copy.
Yes, she has received, Milord, served, Milord. This is the endorsement, Milord. Amrita Pandey, Milord. Even then, Milord, we are.
Mr. Basu, learned advocate appearing for the petitioners.
Copy দিয়ে দিস না।
By application.
এটা দিয়ে দেবো।
দিন এরা এসে
সব করো। ঠিক নামটা পাল্টে দিতে বলছে।
Oh, NPS.
Huh?
That means you are claiming that you will be governed by the old pension scheme.
Yes.
In place of new pension scheme. Your recruitment was
My advertisement was 1997. My selection, Milord, commenced in 1998. Milord, what happened? Fire broke out. Now, Milord, examinations were cancelled. I approached the Milord Honorable Tribunal. Tribunal, Milord, dismissed my application ultimately. I came before Milord, the High Court. Milord, my Lord Justice Chakraborty sitting with Justice Matre, as her ladyship then was, Milord, the division bench, and in other set of matters, Mr. Kashikanto Mohitro, late Kashikanto Mohitro, had appeared for other set of the writ petitioners. Milord, the court acknowledged ultimately our right. Milord, in pursuance of the order dated 29 January 2014, we were all appointed. Now, afterwards, after my appointments, I made an application, Milord, to the authority that you see that my appointment was 29 January 2014, and by virtue of this order, so my right accrued on and date when I filed my claim before the court. So that should be the notional benefit may be given. The Honorable Tribunal, Milord, said, no, we will not consider, because when the Honorable High Court, by its order dated 29 January 2014, these issues were not decided. And accordingly, the tribunal cannot, Milord, grant any such relief. Now, Milord, subsequent to filing this writ petition, I have come across, Milord, certain benefits have been conferred upon the writ petitioners also but in a fragmented way. If one limb of the central government stand is to be accepted, then the other will create illogical conflict with the first one. So that is my contention before your lordship. This application may kindly be taken up and be considered along with my writ petition.
Advertisement was in
1997, 8th February to 14th February. Selections were made from March to October 1998. Appointments could not be made because fire broke out in 1998 November. Now I approach the Honorable Tribunal that the cancellation was made by the Railway Recruitment Board, that all records were gone. But in terms of the advertisement, 8th February to 14th February, we are entitled and eligible.
February to
14th February, the advertisements were made.
Which year?
1997.
Very good. 8th February to 14th February was the employment notice. You participated.
I participated. That was
the examination was cancelled.
Cancelled. I approached
When was
it.
it cancelled?
It was cancelled. 1998. Yes, because November. Yes.
You are a bit slow, Mr. Member.
I'm sorry.
1998,
Yes.
it was cancelled.
Yes.
Now thereafter,
Milord,
the cancellation.
yes. Milord, I am extremely sorry. 1998 fire broke out. October 1999, the notification for cancellation of written examination was October.
Oh, very good. Now you challenge this cancellation notification before the tribunal.
Yes, it was dismissed.
Tribunal dismissed your application.
I came before your lordship's court.
Now where is our order?
Now, page 105. Sorry, Milord, it starts from 104. And
give us 2 minutes.
Yes. My matter starts from 108.
108.
Yes. Unless your lordships go through Milord 104, possibly because this is a part of that order.
Why did you say I heard the matter? I didn't.
No, Milord, sorry, Milord. Yes, Milord, your lordship.
I was thinking of releasing them.
No, Milord, sorry. Nishita, sorry, Justice Talukdar and Matre. Sorry, I'm sorry. Justice Talukdar and Matre.
So you do not want this bench to be.
No, Milord, sorry.
No, you said that.
No, I'm sorry.
Yes,
I said incorrectly, Milord.
Now the courts, which page you are wanting to?
Milord, I was Milord on the Milord page 104.
Very good. Operative portion is one.
The operative portion, Milord, 107. The Railway Recruitment Board, that is such and such, will consider the marks obtained by the petitioner in the written examination held in 1977 pursuant to the recruitment notice dated 3rd February 1997 and appoint the petitioner in compliance with the Railway Recruitment Rules of 1997. It is obvious that only those petitioners who obtain minimum qualifying marks and above will be entitled for appointment after undergoing an interview, if necessary, in accordance with the Railway Recruitment Rules of 1997. We have been informed by Mr. Basu that there is no passing mark for the interview. The respondents will intimate to the petitioners the date of interview by displaying the information of the website as well as by issuing a press notification.
You are reading.
Page 107.
107.
From the top you are reading.
Yes.
Just
internal page 4.
Appointing in compliance of the officer will do.
We have a date of interview. Selection process to 2004 এর আগে হচ্ছে।
There was no fresh applicant.
না,
which we need. Achha, very good. There was any fresh applicant after cancellation?
No, when my turn came, Milord, that is Milord, in connection with the other writ petition, I got the same benefit. Milord, kindly turns Milord page 108.
This is another WPST.
This is another WPST, Milord.
Same challenge.
Same challenge.
Now what did the
court court said, Milord, that I got the same benefit as that was reflected in page 107. Milord, we all were appointed, Milord, in pursuance of this order. I'm sorry.
Now this, they were said, you considered the marks of the written test, then you hold an interview in terms of the 97 recruitment rules. After interview, you became eligible.
We were appointed.
Appointed when?
Milord, our date of appointment, Milord, that is, Milord, 2000 within Milord 2014 we got the chance, Milord. 2914 your lordship's order, and we got appointment. After the appointment, huh? Milord, we have not mentioned 2016. After 2 years.
Very good. You accepted the appointment.
I accepted the
Now, thereafter, you made a prayer that you give me notional benefit
From the date.
of cancellation.
From the date, not from 1998, when Milord, I appeared before the selection board. 97 is the advertisement. 1998 is, Milord, there are three selection date, written examination.
But Mr. Basu, admittedly, you have not worked for that.
No, I have not. But question is, Milord,
Had you been appointed?
Had I been
Would have
appointed?
just-
No, Milord, question is, Milord, that I was not sitting on the fence. I approached the Honorable Tribunal immediately after the cancellation made on 10/10/1999.
What did the tribunal tell?
Milord, Tribunal, Milord,
Tribunal order where
Oh,
it is said.
yes. Tribunal said, Milord, that is absolutely the understanding of the tribunal. That is, Milord, last order. That is page 184. 184. May I read?
Yes.
The applicant has approached this tribunal under section 19 of the Administrative Tribunal Act, praying.
Not the entire order.
No, no, no. Agreed by the decision RRB.
Paragraph 5.2.
Milord, 5.2. From the dated notification dated such and such, it is clear that the selection process consisted of the written examination followed by an interview. This fact was noted by the Honorable High Court while passing WPCD number such and.
Interruption. When was your written test held earlier?
Milord, written test, Milord, on 3 dates, Milord. That was, Milord, it was on 30th 11/1997, 25/1/1998, and 8/3/1998. May I repeat?
Yes.
30/11/1997, 25/1/1998, 8/3/1998.
Very good.
Examination held, Milord.
8/3/1998.
Yes. Now, Milord,
Thereafter it was cancelled.
there now. Thereafter, 7/11/1998, fire broke out.
Fire broke out.
Now,
Was your that means prior to interview the program was cancelled.
yes.
But did you come within the zone of consideration?
Yes, that is why, Milord, I was called for interview because 107.
Called for interview?
Yes, I was called for interview. I appeared. I was selected.
After
After, Milord, after the order passed by.
Not this. I'm saying the earlier one.
No, because
earlier one written after written test.
I was
held.
not called for interview.
Acha. What did the recruitment rules provide that what the cutoff for written test was there?
Yes, that is why I said, Milord, in 107 for Milord, in order to, Milord, there was no, we have been informed by Mr. Basu that there is no passing mark for the interview. Milord, I did not appear in the interview, but in the written examination where I was qualified, Milord,
There was no cutoff.
no, my instruction is no, subject to what learned ASG will say. But it is also impossible.
Madam, you check up whether then anyway, what the tribunal said?
No, Tribunal, Milord, 5.2, Tribunal said that the court note of the court did take in.
সম্প্রদায় যদি 2001-2004 সালে যদি ইয়েটা হয় ওই রিক্রুটমেন্টটা কমপ্লিট হয় কিন্তু অ্যাপয়েন্টমেন্ট তারপরে হয় তাহলে ওল্ড পেনশনে যাবে সেটাই বলতে কিন্তু ন্যাশনাল বেনিফিটটা দিবে
No.
ন্যাশনালটা
Yes.
Now, Milord, the tribunal, Milord, fell into an error subject to
We are placing 5.2.
5.2, Milord. The tribunal fell into an error because of the fact, Milord, the tribunal said my selection, Milord, which was
From the notification,
Yes.
clear selection process for written test, and this fact was noted. Respondents were directed to grant appointment.
followed by an interview. I was never called for interview because before the interview took place, the fire broke out.
Where followed by, you are reading 5.2.
Two, yes.
Please place it.
It is clear that the selection process consisted of written examination followed by an interview. This fact was noted by the Honorable High Court while passing the order. High Court, my lord, did not take into an account that fact. High Court said, my lord, that the interview, my lord, High Court directed by its order dated 29th.
No, it is clear from it is clear that the selection process consisted of written test and followed by interview.
Right.
There is no wrong in that sentence.
No, I said, my lord,
You are
yes,
saying
yes, I understood, my lord.
This fact was noted
By the Honorable High Court while passing the order in WPCT number 53 of 2028, in which the respondents were directed to grant appointment to the applicants after taking interview because the applicants admittedly did not face the interview. This is correct.
It was cancelled.
Cancelled. Now, my lord, in fact, the results of the said interview, written examination, was never declared. Thus, the selection process was not completed till the Honorable High Court passed the order directing the authorities to grant appointment to the application sent after taking the interview if necessary. The selection process which led to appointment of the applicants cannot be considered to have completed with the written examination.
But that the petitioners were not at fault.
Yes.
We had cancelled. In 99, we had cancelled the entire interview process.
His cancellation?
For such cancellation, they were not at fault. Because fire broke out.
It was a
Neither
natural
within your
calamity.
control, nor it was within their
Control.
Yes, next line.
Now, my lord, if necessary, the selection process which led to the appellants cannot be considered to have been completed with the written examination. In the instant case, the process can be considered to have been completed only after the pre-appointment formalities like dedical such are completed. This process was completed in 2014. Therefore, the claim of the applicants for granting them notional benefit from 1999 is not tenable. We also find merit in the contention of the respondent that since the applicants were appointed against vacancies existing at the time of their appointment, as per the order, their appointment cannot be given any retrospective effect. In view of the above, we not find no conformity. Now, Millard, here lied Millard the another questions. The logic, Millard, which weighed with the Honorable Tribunal, Millard.
এইটা ঠিক আছে এটা হ্যাঁ ওই জন্যই তো অ্যাক্সেস আপনি ইয়ে
Yes, Mr. Ortega.
The Lordship kindly adjourn. I will take instruction, come back, or your Lordship, there is no scope for adding interim order. Your Lordship kindly.
We understand. We are just trying to understand.
Yes.
Mr. Bhattacharya, it is not a case subject to what you said. Vacancy notification was made once. So the vacancies in respect of which their claims were at stake did not vary till the appointment. It is not a case that there was enhancement of vacancy. But when there was no fault on their part, neither on your part nor
Not
on
their
part. So they have all retired.
No, we are in the service. Retirement program.
Why don't you, Mr. Bhattacharya, please, this order of the High Court was a follow-up of the
previous
acts which occurred in 1999. Now, notional benefit.
It cannot be too far fetched.
মোহিত শাহ সাহেব যখন চিফ ছিলেন না তখন একটা অর্ডার দিয়েছিলেন কাজ করেছিল কিন্তু
কাজ করেনি ওর আগে থেকে দেবে প্রথম যে একটা প্রেয়ার ছিল he should be given appointment from the date of publication.
হওয়া সত্ত্বেও দিয়েছে
If the appointment was not given from the date of publication, no retirement benefits can be given from the date of publication.
There is a judgment in your favor. Find out. When Justice Mohit Shah was here as the Honorable Chief Justice. So far as I remember, Mr. Bhattacharya, kindly.
Actually, in this matter, Additional Solicitor General requested me, my lord, he will argue the case, my lord, and he is in difficulty only, my lord, your lordship. And I will take instruction, your lordship kindly fix.
In connection with the present application, in connection with the present petition, the petitioners have filed a further application. Additional evidence.
That has not been served upon us.
There is an application which can 1 of 2024 for appropriate. Heard the learned advocates appearing for the respective parties. Upon the application being can 1 of 2024. This was pertaining to the same selection process.
Yes, that is the continuation.
No. This which you have come up with.
No. This is yes, Milad. This application. The application नहीं निलो तो. Oh. Milad, this application, I said, Milad in paragraph. Kindly Milad turns paragraph Milad. Milad. During the pendency of the instant writ petition by an officer dated 31st October 2023, the petitioners were switched over from new pension scheme to old pension scheme as they are eligible for for coverage under Railway Service Pension Rules 1993. Rules 1993, Millard said that the respondent authority said they actually acceded to one of the prayers of the petitioners. Now I said that the policy decision of the government for transformation of benefit from new pension scheme to old pension scheme as that has been conferred upon the employees of the respondent has clearly indicated inter alia that such benefit covers all those employees of the respondent authorities who were appointed by virtue of the notification issued prior to 2004. The particular case is made applicable to the present applicants, taking note of the fact that they are appointed in pursuance of the notice published prior to 2004, that is 8 February 1997. As such, the applicants are justified in setting up their claim with regard to the conferment of other benefits as made in the prayers of the writ petition. Millard, we are switched to.
Pension scheme, how does it? You will be governed by the old pension scheme?
Yeah, I am covered.
Because 97.
They impliedly accepted, Millard.
Here no prayer has been made seeking a direction upon the respondent to.
No, I will not, because I am only because this is
order
no,
that you are governed under old pension scheme.
I am covered. I said, Millard, that this prayer is taking note of a subsequent event, Millard. It was 31st October 2023.
No,
I
Mr.
got it.
Bose, at best you can claim notional benefit.
Yes.
That was your original prayer.
Original prayer.
That cannot be
No. I said, Millard, the government has accepted that we are entitled to switch over from. It can be taken into an account whether it does lend any assistance to the present list.
All right.
Actually, the new pension scheme was applicable mandatorily for the employee who appointed after 1/1/2004. But there was a rider that whose selection process was completed.
Mine also
before 1/1.
I appointed in 2016. My selection process
appointed after 1/1/2004
in pursuance of the prior to 2004 notification, 1997. I said the government on the one hand has accepted that the switching over is permissible and other notional benefits CAT says no.
To exercise an one-time option. No option was given to them.
The analogy in connection with the present writ petition, the petitioners have filed a further application for appropriate orders being can such and such. A copy of the same has been handed over to Mr. Bhattacharjee, learned advocate.
Anamika Pandey. Mr. Anamika.
Has been handed over to Ms. Pandey, learned advocate, appearing for the respondents. The respondents would be at liberty to use an opposition to the said application within a week from date.
10 days. Next week, your lordship, within 10 days.
We are
Into the
liberty.
has to be vetted by ministry.
And better your lordship kindly grant 2 weeks because my lord, it has to be vetted by the department. Then my lord,
said you would be at liberty. This you may not apply also. You may not have to reply because now there is nothing to do. But file an opposition to the said application within 31st, within 31st,
31st.
reply thereto if any be filed within a week thereafter. This the matter for further consideration in the under the same heading in the daily এটা কবে
Chain of affidavit
কোনটা?
to remove the petitioner prayer portion. Because we are taking this point that
further consideration in the daily supplementary dispatches on 9th February. তার আগে একটা লাইন দিয়ে দেব। We handed over a copy বলেছো না to Miss Hon'ble learned advocate তার আগে তারপরে একটা লাইন দাও the said application shall be heard along with the main writ petition তারপরে দাও would be at
Well, since it has not been listed, by consent of the parties, this matter is taken up with the can one. He's your
Can is
office said-
treated as on guest
one
list.
is not there.
No, it was not there.
One is there.
আচ্ছা।
GG
তুমি বললে লিস্টে নেই? আমি শুনলাম জজ সাহেব বললেন
Can 124 is
yes, yes. কবে আসবে বললে?
Ninth. Right.
But I am for the respondents in this case.
Yes. মেনশন করে তুমি শর্ট করেছো দেখি দাও তো অর্ডার শিটটা It's a fresh application.
Yes, ma'am. This application.
It was never heard.
Never heard. This is the first time this April.
Item number
11. Section 5 is there.
section 5 is there. How many days?
74 days, but no explanation.
No.
No explanation. Nothing. Your lordship kindly see the, but kindly see the application, my lord. Kindly see the application. Only one paragraph.
You are not so technical.
No.
You are becoming technical.
I have never, but my lord, so far this case is concerned, well, it's a total lackadaisical attitude on the part of the my lord applicant.
Total
Lackadaisical attitude. My lord, we have given offer of appointment in the year 2013 on compassionate ground. She has refused. Then my lord, she told that yes, I am in graduate. Kindly allow me to class 3 post. We say all right. Office assistance we have offered. For the purpose of office assistance, one's computer certificate course is required as per our policy. She told us, yes, kindly give me some time so that I can take admission and complete. We have given time till 2015, 2017, till 2022, she didn't turn up. In the meantime, 2020, we have cancelled the appointment. It's a compassionate appointment. Since 2013 till 2020, she didn't take any steps.
Why?
Lord, maybe he is a higher qualified, maybe. But I am told that she took MA in English from Rabindra Bharati University. I am told. That is why. So, there is no fault on the part of the, it's a compassionate appointment. It's not a matter of right. Your lordship knows me.
You have been given a copy. Section 5, you have given a copy.
But only one paragraph. Just, my lord.
No one appears today on behalf of the petitioner. These matters were mentioned.
Yes. This was mentioned upon notice. I told him.
No one appears today. Dismiss করে দিল। Dismiss করে দিল। এইটা কি combined list এ ছিল? এগুলো?
Yes, it was in the combined list.
দেখো আপডেট করে আসছে না।
এটা দিয়ে দেবেন তো।
Do you know your other side?
Yes.
Who is the advocate?
Well, advocate on record, I think fine.
Vivek Kumar Pandey.
That I don't know, but senior maybe Kullan Kumar
No
Chakraborty.
one appears today on behalf of the appellant. Though Mr. Learned advocate appearing for the respondents is present. In connection with the present writ petition and records reveal that in connection with the present writ petition, an application for condonation of delay being canned for 2023 has been filed. Stop. the respondents would be at liberty to use an opposition to the same within a week from date.
Not week, me not 2 weeks.
Which was this? Within 2 weeks from date, reply thereto if any be filed within a week thereafter. List the matter for further consideration on 9th. Yes.
I'm grateful to you.
In 12 appearing on behalf of the Union of India.
Lordship, I am for the appellant.
What are the two applications?
Lordship, one is a stay application and another is a Section 5 application.
How much delay?
58 days, Lordship. 55. Affidavit of service, Lordship. $55.
What is the matter about?
Lordship, the writ petition was filed. The petitioner was an employer in the CIFS. A disciplinary proceeding was started and he was terminated from service. Challenging that order, the writ petition was filed, but the writ petition has been dismissed on the point of jurisdiction. The merits has not been gone into. Lordship will kindly see the order impugned is at page 90 of the stay application.
What is the wrong with the order?
Lordship, I have three grounds of which. The first is, Lordship, Article 226, Clause 2 of the Constitution, which says even if the authority is outside the territorial
Madam,
jurisdiction.
you have already accepted the jurisdiction of Telangana. Your application is
That was, Lordship, on a different writ petition, Lordship. It was not
Yes.
pertaining to this.
Maybe, but it was pertaining to the place of work you were working.
But Lordship,
That matter is still pending.
no, Lordship, that has been
The
withdrawn.
court has recorded it is pending.
Lordship, thereafter it was withdrawn because that was subsequently the final order was already passed. So that had already become infructuous.
So, when in this proceeding, which charge sheet did you challenge? Fresh charge sheet?
No, that charge sheet was initially challenged, Lordship, but thereafter final order has already been passed. And this writ petition was challenging the final order.
Final order, yes.
So initial order you challenged before?
Initially, the charge sheet was challenged. When the charge sheet was submitted against the petitioner, at that stage, very nascent stage, the charge sheet was challenged.
Very good.
Thereafter, the entire proceeding took
Was
place and the
completed and you were terminated.
final order was passed. Challenging the final order of termination, this writ petition was filed.
But the
Cause of action, part cause of action, না বলুন কি করে cause of action কি করে এখানে
you committed an act for which you were charge sheet.
Lordship.
Now that against that charge sheet, you filed the writ petition. But during pendency of the same, the final order was passed. You withdrew the writ petition. Now the final order was passed on the basis of that charge sheet.
Lordship.
So how does any part of cause of action arises here?
Lordship,
26(2), if you can show that any part of the cause of action has arisen, we will interfere.
Lordship, I am also relying on the Nawal Kishore's judgment.
Let us first clarify the facts.
Lordship, I am Lordship, the
Have you
appellate
brought this
against the
coordinate bench judgment? Have you brought? You have got it.
Lordship, challenging the final order. I had
Tell us charge sheet. The charge sheet was dated 1st September 2021.
Lordship.
And what that writ petition, show us the order passed in that writ petition, Telangana High Court. Have you annexed that?
No, Lordship, it was after the filing of the appeal.
So you bring that order.
Lordship.
এটা ছাড়া কি করবে?
After removal of service, that was at Hyderabad. Appellate authority at Hyderabad, appellate authority appeal has been preferred in Hyderabad.
No, Lordship.
Revision also.
That was by post Lordship, and the appellate order was
Removal of service from Hyderabad.
In the writ petition.
My lord, that was in Hyderabad.
Now that during pendency of the writ petition, you pass the final order. Against final order, they went to the appellate authority. And thereafter revision.
After revision.
Now they come and file the writ petition challenging everything.
Challenging only final order removal of service. Thereafter, appellate authority's order and revision order has not been challenged.
In this writ petition. The very good that merges because if the
and Lordship, the appellate authority order and the revision authority order, those were communicated to me at my address, which is within this jurisdiction, Lordship.
What judgment you are relying upon?
Lordship, the Nawal Kishore judgment of the Supreme Court, Lordship, which says Lordship will kindly come to paragraph 16 and 17. Second last page. Second last page of the judgment.
Yes.
May I read, Lordship?
Yes.
Paragraph 16. Regard being had to the discussion made herein above, there cannot be any doubt that the question whether or not cause of action wholly or in part for filing a writ petition has arisen within the territorial limit of any high court has to be decided in the light of the nature and character of the proceedings under Article 226 of the Constitution. In order to maintain a writ petition, the petitioner has to establish that the legal right claimed by him has been infringed by the respondents within the territorial limit of the court's jurisdiction. We have perused the facts pleaded in the writ petition and the documents relied upon by the appellant. Indisputably, the appellant reported sickness on account of various ailments, including difficulty in breathing. He was referred to hospital. Consequently, he was signed off for further medical treatment. Finally, the respondent permanently declared the appellant unfit for sea service, and as a result, the shipping department of the government of India issued an order cancelling the registration of the appellant as a seaman. A copy of the letter was sent to the appellant at his native place in Bihar, where he was staying after he was found medically unfit. It further appears that the appellant sent a representation from his home in the state of Bihar to the respondent claiming disability compensation. The said representation was replied by the respondent, which was addressed to him on his home address in Gaya, Bihar, rejecting his claim for disability compensation. It is further evident that when the appellant was signed off and declared medically unfit, he returned back to his home in the district of Gaya, Bihar, and thereafter he made all claims and filed representation from his home address, and those letters and representations were entertained by the respondents and replied to, and a decision on those representations were communicated to him on his home address in Bihar. Admittedly, the appellant was suffering from serious heart disease and breathing, which forced him to stay in his native place, whereall he was making all correspondence. Prima facie, therefore, considering all the facts together, a part or fraction of cause of action arose within the jurisdiction of the Patna High Court, where he received the letter of refusal disentitling him from disability compensation. Apart from that, the counter affidavit of the respondents and the documents annexed therewith, it reveals that after the writ petition was filed in the Patna High Court, the same was entertained and notices were issued. Pursuant to the said notice, the respondents appeared and participated in the proceedings in the High Court. It further reveals that after hearing the counsel appearing for both the parties, the High Court passed an interim order directing the authorities to pay at least a sum of tax, which shall be the subject to the result of the writ petition. Pursuant to the interim order, the respondent has remitted to the bank account of the appellant. However, when the writ petition was taken up for final hearing, the court took the view that no cause of action, not even a fraction of cause of action, has arisen within its territorial jurisdiction. Lordship, prior to this,
Tell us when were you give us the dates.
Lordship.
Chart sheet was 1st September 2021.
Lordship.
Have you annexed all those?
Lordship, it is annexed in the writ petition, Lordship. To the stay petition, the charge sheet is page annexure P1, that is page
Mr. Dalal,
47.
do you want to bring anything on record? You want to file opposition or we take it up?
I want to file opposition.
Lordship will consider one more point. Lordship will consider one more point. Earlier, against
This
the
order is totally distinguishable on facts. That you also understand.
Lordship, earlier, Lordship will hear me once. Earlier, this petitioner had preferred a writ petition before this High Court for against the same respondents for his mother's medical bills, clearance of his mother's medical bills. This High Court has passed an order and the respondent has accepted the order and the medical bills were cleared, Lordship, without challenging the order of the High Court. The single bench order, Lordship. Lordship will kindly see page 83. That order. It starts from page 82 of the stay application.
Page
82, it's the order starts. The order of the single bench. Now, operative pages is page 83, Lordship. Page 83, third paragraph, Lordship. May I read? Considering the said facts, I am of the view that the petitioner will be subjected to greater hardship if he is relegated to file a writ petition before the Telangana High Court on the ground that the medical bills were submitted at petitioner's office at Telangana and the rejection took place at Telangana. On the other hand, Union of India, being the principal respondent, will not be placed in much inconvenience if it has to defend the litigation before this court. Union of India has empaneled advocates in this court who can effectively represent the respondents and produce before this court the necessary papers and documents, if so required, by collecting the same from the employer. On this ground alone, I am rejecting the contention of the respondents and hold that the writ petition is maintainable in this court. And this order was not challenged in the appeal. The respondents accepted this order and the medical bills were released.
His mother was treated in Howrah hospital. At that point of time, his mother was treated in a Howrah hospital.
এটা কি ওরা এই যেটা part of cause of action বলছে
তার মায়ের মেডিকেল যদি কভার হকদার হয় তার মানে যদি একটু বাসিন্দার থেকে আসতে পারে
পিটিশনার বাপ টাকার মামলা করেছে ছেলেটা। All right, you come with what you have to ask. Delay of how many days?
55 days.
আসুন। The present appeal has been preferred, challenging an order dated
15th of May
15th
2020.
of May 2023, passed in a writ petition being WPS 6905 of 2023. In connection with the appeal, an application for condonation of delay being can Atho has been filed. Can one of such and such has been found. Stop. Upon Upon hearing Ms. Basu, learned advocate appearing for the appellant, and Mr. Dalal, learned advocate appearing for the respondents, and considering the amendments made in the application for condonation of delay, we are satisfied with the explanation given towards the delay in preferring the present appeal. Stop. Accordingly, such delay is condoned, and the application being can such and such is disposed of. Stop. Next part, the application being can 2 of 2023 has been preferred for setting aside the order impugned in the appeal. Stop. The respondents would be at liberty to file their affidavit in opposition to the same within
8 weeks. 8 weeks.
8 weeks. Why?
But it's from Hyderabad, but it's waiting. After drafting, it will be waited. Thereafter, it will be filed. The time is necessary.
8 weeks would be too much. Do it within 4 weeks, Mr. Dalal. 6 weeks. 6 weeks, reply thereto if any be filed within 2 weeks thereafter. The parties would be at liberty to mention the matter for final hearing after expiry of the period as fixed above towards exchange of evidence.
My lord, asking for coordinated with judgment. 2 copies
Yes,
have been
you
handed
gave
over. Yes.
Gave it to us. You take it back, your judgments. এটা ওনাকে you annex Mr. Dalal the appellate authority order and
Absolutely.
That is annexed, Lordship, in the
that is
stay
annexed.
application.
State annex করা আছে, ওটা করা আছে। Revisional authority বোধহয় হবে।
Revisional annex করুন।
It is absolute discretion of the maintainability ওখানে তোমরাও মনে তো দেখো পুলিশ হেরে গেল অ্যাকসেপ্ট হ্যাঁ তুমি যেটা বলছো ঠিক বিলটা রেজড হচ্ছে কি
কোনটা ছিল তাহলে?
রেজ হবার যে কজ অফ
তো তোমাকে কপি নিয়ে তাহলে তোমাকে দিয়ে ফেলেছি পুরোনো ব্যাপার
দিকেই কজ অফ অ্যাকশন আসতে পারে তাহলে মেডিকেল বি প্লেসই করতে পারবে
সেইটাই।
Yes, call the next.
The next matter, we have instruction to appear on with the respondent number 4, Lordship.
Yeah.
And I am praying for 2 weeks' time to file my affidavit in opposition to the application under Order 41, Rule 27, my lord.
Item number
13, my lord.
Lordship, I beg to appear on behalf of the appellants in this matter. Previously, there was an order on 16th May 2023. We filed an CAN application under Order 41, Rule 27 for filing additional evidence before the court, and that was granted by your lordship, and an order was passed for over them to file an affidavit in opposition. That has not been filed yet, my lord.
What is the suit for?
This was a suit for partition, my lord.
But I'm new in this matter, lordship. Kindly grant me some time. I shall file my affidavit in opposition and come back to your lordship as your lordship will fix the matter.
Even lordship, I also prayed on the last time because I am appearing for the first time in this matter, my lord.
Now, when was that order passed?
Lordship, that was an order of 16th May 2023, passed by your lordships.
You are for whom?
I'm for respondent number 4.
Mr. Learned advocate appearing for the respondent number 4. Who are the others? Any
Lordship,
other?
I'm not appearing for the others.
Lordship, that was served.
Paper book is ready.
Yes, my paper book was ready. And
Then service upon you.
there was a direction upon them. We served upon them, and from the order dated 16th May itself, it reflects that they didn't appear even after the service. However, there was a direction upon the respondent number 4 to file the affidavit in opposition. Since a registered document was brought on record, and my learned friend is probably
Mr. De Learned advocate appearing for the respondent number 4 prays for extension of time to file the affidavit in opposition to the application being Can 5 of 2023. Stop. Let such affidavit in opposition be filed within
3 weeks time as well. If your lordship grants me 3 weeks time.
Prays for extension to file the affidavit. Stop. Such prayer is considered and allowed. Stop. Next. Let such affidavit in opposition be filed within 3 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. Stop. Next para. The parties would be at liberty to mention the matter for final hearing after expiry of the period as fixed above towards exchange of affidavits. একেবারে উপরে লিখে দেবে Mr. Kobil Learned advocate appearing for the applicant. Yes, next.
Grateful to your lordship.
Lordship, I beg to appear on behalf of the appellant. This was the matter pertaining to that school service commission.
My lord, in this matter, my lord, I appear on behalf of the school service commission led by Dr. Patra. My lord, previously there was a direction that, they have used a supplementary affidavit. No, paper books are ready.
Abar supplementary.
No, lordship.
No, they filed and
document-
your lordship directed us to, my lord, file an exception to that. My lord,
No, we wanted to see that. We wanted you people to check up whether his name was there. What did we ask?
Lordship, yes, may I humbly submit, Gandhi. We concluded our argument. There was a direction upon them that we filed a supplementary affidavit in connection to only appellant number 2, that there were 4 seats left. For that, lordship gave a direction upon them to file an exception to that affidavit. Along with that, there was a direction upon them to produce the panel before your lordship, which was prepared according to them into one is to
That was not in our order.
lordship.
yes.
That
Only
we-
this liberty was given to the commission, my lord, to file this exception.
But, we asked Dr. Patro
Yes.
to check up those records. We said that panel
Lordship.
Yes. My lord, I have.
and come and
Yes,
to
I have
come
got,
back.
my lord. I have brought it, my lord. Let us file it today, and my lord, Dr. Pati, your lordship knows, my lord, he is
You
in.
have got those records.
Yes. Panels
That
are.
is with you.
Yes.
What?
My lord, I will produce it on the next day, my lord. My lord,
It is understood that you will produce the records. Don't say that again. Give time.
no, I'm not seeking for time, my lord.
This
I
have
have.
we have heard extensively
Yes,
with my brother.
my
That
lord.
is why we want to finish it off.
My lord, my lord, kindly, my lord, fix. My lord, Friday.
Tell us when can you file?
My lord,
You want to file opposition to this?
exception, my lord, I have. It is already ready, my lord. My lord, I have already served the copies.
Already one extension was taken in 6th of October.
This order was passed prior to the puja vacation.
Yes, my lord. This is the exception.
Then what is the problem? Now no exception.
No,
You
no,
want
Dr.
to file.
I don't want to file because I have already concluded my argument. My only humble submission before your lordship regarding this particular document was that that throughout this litigation, it was submitted before your lordships that even before the Honorable Apex Court that they could not, vacancy was carried forward since there was no availability of candidates. However, from this affidavit which has been filed before your lordship, it is crystal clear that there was availability of candidates, but that was not done.
So very good. You
My lord.
put in a formal
I will,
protest to that.
I will, lordship. I will.
Do it within a week.
I will.
Mr. Mr. Bandopadhyay, learned advocate, appearing for the commission, files the exception. Stop. Let the same be kept on record. Stop. A copy of the same has been handed over to Mr. Kobir, learned advocate, appearing for the appellants. Stop. He prays for an accommodation to use a reply to the said exception. Stop. Let such a reply be filed within a week from date. Please the matter for further consideration in the daily supplementary list of this court on 9th February. On 9th February. Stop. The
9th.
matter shall be treated as hard in
The 9th.
Grateful.
9th February, madam.
9th February.
Grateful.
পাঠাট করা আছে?
পাঠান।
এটা দিও না।
Extremely good.
Grateful.
Mr. Bandyopadhyay, you assist us with the records and finish it off.
My lord. I have already, my lord, compiled those, my lord, panels.
Take an adjournment.
No. Adjournment, if any, my lord, only because of Dr. Patra's availability, my lord. That matter is going on in the special assigned bench, my lord.
Grateful.
Lordship, item number.
Please. এই যে পাঠ করবে হাজার হাজার You can appear.
Lordship, I am not engaged in this matter. I have been asked only.
Number?
This 15, 1 5.
Let us see what is the matter. What is the matter, Mr. Banerjee?
Yes. Now, this matter has got a checkered history. The issue is with regard to enhancement of payments of casual workers in terms of the government circular itself. Now, first, Your Lordship, it was hit before the tribunal on 2015. 117. Now, tribunal's order on page 117 sent us to the authority concerned to decide the issue. Now, against the same, there's a reasoned order which reflects from page 123, which says, for a moment, if Your Lordship turns to page.
Tell us the story, then what happened? Rejected.
Rejected. And rejected in a very ambiguous term that the papers being used and the documents being used are all fake in nature. Once again, there's a re-challenge before the tribunal. Tribunal is of the view that since they have done so, it is to be taken to be a sacrosanct, and therefore your cases are rejected. We hit once again before the High Court. High Court is of the view on the that the person concerned who are entitled to take the decision, he heard it from someone else and he decided. Rejected. Once again, relegated the matter to be decided. Now he is of the view with this rejection that this time also is with a rejection, but fake aspect is being obliterated. You could not produce any document, therefore rejected. That aspect is given a go by. The same authority who is deciding the issue.
Please tell us, then what happened?
Then we applied for a RTI. We applied for RTI.
You didn't challenge the order?
No, this is the challenge. We are before here.
No, the second order after relegation by High Court, that was challenged in tribunal.
No, the second order, which was already turned down, is being challenged here in this petition. They have already, because tribunal has already came to a final conclusion.
But tribunal is the court of first instance. You have to go before the
No, no,
tribunal.
Lordship, kindly appreciate over here. Tribunal, we have been over here in the tribunal twice. Second, Lordship will
What is the subject matter of challenge in the present writ petition?
present writ petition is the challenge over the reasoned order which was passed pursuant to the order of the High Court.
So for that, how can you file writ petition here? You have to challenge that before the tribunal.
I know what's falling from the Lordship's mind, but the difficulty is that tribunal has already came up to a conclusion.
Maybe.
Conclusion. What I'm on, subject to sanction, what I'm on, we have already applied for an RTI. RTI, subject, they have given answers that.
When was the
Yes.
rejected? Last rejection was
It is 22, page 133.
Very good.
Pursuant to the High Court's direction itself.
ঠিক আছে.
It's a repetition of the order, except that fake aspect is being obliterated.
So show us L. Chandra Kumar that when High Court has directed relegation, High Court will now consider the fresh order, doing away with the court of first instance. Show us Chandra Kumar.
Let me come back.
Why come back? There is nothing.
I knew this question. Right.
You also know that, Mr. Banerjee, there is nothing in this matter.
No.
This is a 22 order. You better go and immediately file it before.
No, the tribunal always made up his mind.
Maybe, but you have to touch the tribunal and come to us.
The difficulty is this only one thing what I'm on.
No difficulty.
No, page 144, it reflects.
You advise them to file it here, sir. You are a seasoned advocate.
No.
Huh?
I
You are
knew
not there.
what's falling from Lordship's mind. But since this is a no, this I need to travel once again over here.
সেটা তো চন্দ্রকুমার থেকে চন্দ্রকুমার বড় করে
No, we was of the view that there can be some solace from here. Over there, in fact, tribunal is very difficult to approach. Now, there's one bench only.
Mr. Banerjee,
Lordship knows my difficulty.
we know maybe you are fixing, but the procedure has to be followed, na?
But only what I'm on, if your Lordship.
No, then it will so happen. Everybody will about the situation has now so occasion. The tribunal, one member sitting, we will not get our.
In fact, to
matter
be honest, I moved the matter before this court with a direction on the tribunal. It should be decided in 1 month. The moment I place the order, he says I can't do.
We cannot
No,
act contrary to a constitutional bench judgment. You have
No,
had it been a case that the tribunal was keeping the matter pending, doing nothing.
In fact, that will be the situation. In fact, that will be the situation. Lordship also knows. She was here.
Let us not.
But only what I'm on.
Any judgment you show us that you can directly come to High Court.
Yes, sir. Lordship, can you give me some time? If your Lordship is, Lordship can throw me out on the very next day also. At least some conscience over here from this side. If I can show some light.
You will not be able to.
At least my conscience will be
You
clear.
have unnecessary. These persons are suffering, sir. You should go and approach the bench.
That is also
Come back.
difficult. We are trying our luck every day.
You took time. See,
Whatever happened is happened. I cannot deny. But kindly post it after 1 week. Let me come back. Kindly throw me out today.
returnable motion.
Returnable.
Come on the next day when we will be taking up. এই কবে নিই আমরা?
কবে নিয়ে যাচ্ছ? My lord, affidavit services here.
মঙ্গলবার, Tuesday.
Tuesday.
This Tuesday.
Kindly Tuesday week. Make it Tuesday week. It would be at least if I can make some workout. Tuesday week would be better.
In course of hearing, in course of affidavit of service filed by be kept on record. Petitioners be kept on record. In course record. Stop next para. In course of hearing, comma, Mr. Banerjee, learned advocate, appearing for the petitioners is for an accommodation to avail necessary instruction. List the matter for further consideration under the same
30.
এইটা It's better you withdraw and go to the tribunal. Don't invite comments from us. Don't invite that from us. It will be difficult for you.
Kindly post it on 30th.
You come with instruction
We do run it for.
whether release this matter for further consideration under the heading to be mentioned in the daily supplementary list of this court. Tell us when.
30th, 30.
On 30th. You better you withdraw and immediately go so that you can do not face the limitation issue before the judge.
And in fact, again, that too.
That is your choice. Now, if you do not want to,
Now,
yes,
since your lordship is not
tell
touching.
Mr. Mukherjee to be here next 30th. Yes.
Great.
And number 16.
Not talk to my. Lord, I appear for the petition. Lord, I am aggrieved by the order which is appearing at after page 104.
So last occasion you said that proceedings have been initiated and it will take some time for conclusion.
My Lord, that has been stayed by the tribunal in connection with another original application.
Oh, then
my Lord, I have today, my Lord, this is with regard to suspension. This matter, my Lord, your Lordship heard that this matter yesterday, my Lord, my learned junior had come to pray for adjournment on my ground, my Lord, because it was submitted subject to correction by my learned friends that we have agreed, we have revoked the order of suspension. Now we are challenging that order, my Lord, before your Lordship. That is being assailed before your Lordship, which is appearing at after page 104.
Who is your other side, Mr.
I'm led by Mr. Mojumdar.
Mr. Mojumdar is appearing.
Yes. Both parties agree and submit that suspension order has been revoked, and to that effect, order of 9 has been brought on record.
My Lord.
Now you are.
But I am aggrieved by the other part. Let the period that he was placed under suspension be regularized in accordance with law. But that was not my revocation order. I am aggrieved by that other part. But in fact, if Lordship kindly sees, which was placed before the tribunal.
No, regularize means what? You have to take a decision, no?
But I have to take a decision after conclusion of the departmental proceeding. But the tribunal observed.
Be communicated to the applicant within 4 weeks.
4 weeks, let the period that he was placed under suspension be regularized in accordance with law, and the decision be communicated to the applicant within 4 weeks by the competent authority.
So, Mr. Siddiqui, is it a case that you are not allowing him to join?
No, he has joined. He has already joined.
Then
suspension I have lifted. Departmental proceeding has been stayed.
Then how further regularization?
Regularization of the period of the period during which he was suspended. The learned tribunal has asked me to take a decision with regard to regularization of the period of suspension.
So, Mr. Siddiqui, if a suspension goes,
my Lord,
then automatically I will be in service.
But the suspension goes because the law, my Lord, in this regard, because he is the IPS officer, he is guided by, my Lord, this All India Service Discipline Appeal Rules 1969. Now, my Lord, the law in this regard that once a suspension order is issued, a departmental proceeding is initiated. After the issuance of suspension order, I have to intimate the central government. I did not do so. After initiation of this particular suspension order, I did not do. The central government told me that since you have not intimated me within the time frame, so your suspension order is bad. So my suspension order becomes bad when the central government intimated me, and thereafter I took a decision, yes, suspension has to be revoked. And I placed before the learned tribunal the correspondence saying that I am revoking the order of suspension, and that period of suspension will be decided after the conclusion of the disciplinary proceeding. Even the All India Service Rules, which governs the applicant, says that the period of suspension will be decided after the conclusion of the departmental proceeding. That rule also says.
We are trying to understand suspension, central government, state government suspension has been revoked. Now he is already in service. Now, by regularization of this period, what do you mean?
The period during which he was
not a break of service because he was in suspension.
But that has to be decided after the conclusion of the departmental proceeding. Lordship, kindly sees the rules. Lordship, my lord, I'll take your lordship directly to the rules. Page 91.
Join করতে দিন।
জয়েন করতে দিচ্ছে কিন্তু সাসপেনশনটা তো একটা যদি সেন্ট্রাল গভর্নমেন্টের কাছে পাঠানো যদি ম্যান্ডেটরি হয় তাহলে ফেলিওর টু সেন্ড ইট এটা তো
রেগুলারাইজেশন বলতে কি বোঝাচ্ছে তো আমি বুঝছি না। এই যে বলছে না রেগুলারাইজ করো
ওই পিরিয়ডটা,
ওই পিরিয়ডটা রেগুলারাইজ করার সাইজ হয়েছে তো এখনো জন্মায়নি ঘটনা। Yes, Mr. Siddiqui.
My lord, I'll first tell you, my lord, your lordship first takes up pages 89 and 90. That is the order of revocation of suspension.
No, but before justice, before the other bench,
the other bench, my lord, asked me to take instruction within which time I will conclude the departmental proceeding.
Oh, I see.
But that departmental proceeding is at present stayed in connection with the other original application. There are two original applications, my lord, subject to correction, which has been filed by the applicant.
Now this original application opposition reply was used.
They did not file for a substantially long period of time. It has been posted on 21st February for final hearing.
21st February.
In the meantime, the opposition has been directed to be filed. Now, writ petition at the behest of the state government is not maintainable. I shall satisfy your lordship if required at all, in view of the admission made by the state.
Yes, Mr.
Your lordship, kindly sees page 89.
Why we will send them back to the tribunal for final hearing. When it is 24th February, what is the use of
The tribunal, my lord, I am just aggrieved by this aspect. The learned tribunal
has
my lord,
take a decision and to
according to law.
Now, if your lordship,
Mr. Siddiqui, what can be the order you will pass? The order which you will pass is regularization of the period.
My lord, that can be, my lord, done only after the conclusion of the departmental proceeding.
Now, Mr. Mujumdar, what regularization is required?
Please see page 102, not whether your lordships are at all required to go into this issue at all or not. Please see 102.
We will go through it, but Mr. Mujumdar, tell us now.
But it was after 30 days, the suspension did not remain at all.
Very good.
So the central government's decision to revoke the suspension.
He is saying that yes, we have revoked the suspension.
Right.
We have brought him back in service. Now, what further regularization is required?
That's right. Not the state government is not at all aggrieved. Please see page 102. It accepts the central government's decision.
But I have accepted it.
Please see page 102.
Yes, 102.
After 102, how is the state government aggrieved at all? Please see.
By what? State government is not aggrieved. State government is aggrieved by the fact that tribunal is now asking them that you take a decision as regards regularization.
Please see 102. Please see 102.
Yes, Mr.
My lord, I'll
From the above discussion.
Let him finish.
my lord, that man is senior friend, my lord. He's senior to me, my lord.
No, if he has finished, I shall conclude. That's his point, I think. Very well.
Now, my lord, my lord, this is the order of revocation of suspension, which is at page 89.
Page 89.
89. My lord, I will not trouble your lordship with the entire contents of the order. Page 90, if your lordship comes.
Yes.
And now, therefore, the governor, after due consideration of the facts and circumstances, is hereby pleased to revoke the order of suspension of Sri so and so with effect from 4th of June 2021. Next line is very vital, my lord. The treatment of the period spent on suspension shall be decided after the conclusion of the departmental proceedings are initiated against him. Now, this is the order which was placed before the learned tribunal, that I have revoked the order of suspension, and that period will be decided after the conclusion of the departmental proceedings.
Mr. Siddiqui, just I was questioning myself.
My lord.
This that today you suspend, you revoke the suspension, you bring that person in service, and say that suspension was operative for 1 year. So you are meaning to say that regularization means what? That you have to take a decision that that period shall not be treated as break-in service.
Break in service.
All right.
And if your lordship kindly sees,
In service
my lord,
question does not arise
my
in
lord,
suspension.
my lord, I'll come to
Suspension, it is either spent on duty or not spent on duty. Service
my
is
lord,
always
my lord,
constant.
whether he has spent, my lord, I'm grateful to my learned friend, my lord. If your lordship now comes to the All India Service Rule which guides it, the All India Service Rule which is appearing at page 91. This is the All India Service Discipline Appeal Rules. Starts from page 91. I'll take your lordship directly to the two vital rules, rules 5B1A and 5B, which is appearing at pages 98 and 99. 98 at the bottom.
Yes.
Lord, 5B1, when a member of the service under suspension is reinstated or would have been so reinstated, but for his retirement under the All India Services Death Cum Retirement Benefits Rules while under suspension, the authority competent to order reinstatement shall consider and make a specific order regarding the pay and allowances to be paid to the member of the service for the period of suspension ending with reinstatement or the date of his retirement on superannuation as the case may be, and whether or not the said period shall be treated as a period spent on duty. Thereafter, my lord, 5B6.
Yes.
Where suspension is revoked pending finalization of the disciplinary proceeding or proceedings in a court, any order passed under sub-rule 1 before the conclusion of the proceedings against the member of the service shall be reviewed on its own motion after the conclusion of the proceedings by the authority mentioned in sub-rule 1, who shall make an order in accordance with the provisions contained in sub-rule 3 or sub-rule 5 as the case may be.
So what is sub-rule 1?
Sub-rule 1, my lord, when a member of the, I've just read out to your lordship,
That
under
is
suspension.
5B, 5B sub-rule 1.
5B is sub-rule 1. When a member of the service, once more, my lord, I read it for your lordship's convenience, my lord. When a member of the service under suspension is reinstated or would have been so reinstated, but for his retirement under so and so, while under suspension, the authority competent to order reinstatement shall consider and make a specific order regarding the pay and allowances to be paid to the member of the service for a period of suspension ending with reinstatement or the date of his retirement or superannuating as the case may be, and whether or not the said period shall be treated as a period spent on duty.
Yes.
After conclusion of the proceeding by the authority, my lord, we will decide whether the person, the period during which he had remained suspended, whether that period should be treated on duty or not on duty. Duty which has, the period has been spent on duty or not on duty. But I am only on that. My limited, my lord, purpose for filing this writ petition is that.
How long was the period of suspension?
My lord, the period of suspension.
1 month.
1 month.
1 month. Achha. Mr. Siddiqui, where is the order of suspension?
Page 32.
32. 1 month. 1 month means, my lord, my senior friend has said 1 month is the date within which we had to intimate the central government. But he was suspended subject to correction for a year.
Suspension stood revoked from 4/6/2021.
Right.
So the suspension was for 1 month only, 30 days.
From retrospective effect.
Retrospective. No, when was he suspended? 5th
On
of
5th
May,
of May 2021,
he was suspended.
he was suspended.
Very good. Then,
Now, my lord, on the central government issued a communication to us at page 80. This is of 30th of December 2021, saying that you could not have kept this suspension order without intimating us. You should have intimated us in accordance with the rules. If your lordship kindly sees the fourth paragraph, serial number 4. This is dated, my lord, 30th of December 2021, because the number is this date is illegible.
yes, para 4.
Para 4. In the instant case, since neither the charge sheet was issued within 30 days, nor the suspension was confirmed by the central government, the suspension of Sri So-and-so already stands revoked from 4th of June 2021, as per the provision of Rule 3.1 of All India Service Rules. Accordingly, state government is advised to issue immediate orders regarding revocation of suspension of Sri Debashish Dhaur with effect from 4th June 2021. So that revocation order was passed
Within a revocation 5th of December, 5th of May. 5th of May 2020.
21 is the suspension order.
Suspension.
Order. Thereafter, this is the communication of the central government of 30th of December 2021, saying that you should have intimated me before 4th of June 2021. On or before 4th of June 2021. My lord, and subsequently, I have shown to your lordship, the order was passed on 9th of June 2022, which is appearing at page 89 and 90.
Yes.
revoking that suspension order with retrospective effect from 4th of June 2021.
So the suspension was for 1 month.
Suspension was for. We have now, my lord, this period of suspension, my lord, has to be determined whether it is on duty, spent on duty or not. My only submission,
Mr. Mojumdar referring page 103. What is that?
Page 120.
That is a
102.
102. March 2022.
Lordship, subject to question, my senior friend will be relying upon the last paragraph, I think.
Last two paragraphs.
Last two paragraphs at page 102. No, paragraph 8 to bodai. What is the last paragraph? 8. Serial number 8. The last numbering paragraph.
Was
that
suitably informed on the
date of his appeal.
Appeal against what? Appeal against suspension.
But appeal against
No, this is regarding suspension of Debashish Dhaur.
That Sri Dhaur was suitably informed. This is the communication by the Home and Hill Affairs Department, my lord, to the Under Secretary, Ministry of Home Affairs.
This is 25th, after 25th March 2022, the governor passed the order on 9th June 2022.
Well, this letter was issued because the central government sought for a stand from us with regard to the departmental proceeding, because the charge sheet was not submitted to us, and the central government also asked, in terms of the rule, we were supposed to serve the copy of the appeal which was filed by the applicant subject to correction to the
appeal against suspension.
Appeal against the departmental proceeding.
No.
Memorandum of appeal.
Appeal was on two grounds. One was against the suspension. The second was for challenging the charge sheet.
Yes, then what is this?
Appeal? Well, there were two appeals. One appeal was with regard to one charge sheet and one suspension order, and the second appeal was only with regard to the subsequent charge sheet.
Yes.
That was the
There were
case.
two charge sheets.
There were two charge sheets.
He was suspended against the former charge sheet.
He was suspended as the first charge sheet.
So you during season of that you issued a second
charge sheet.
কি করে করেন? Can that be
Well,
done?
this is with regard to different sets of charges. One was with regard to dereliction of duty during the election time.
No, now kindly come to page 101. What is your
102.
explanation? What you are saying?
Sridhar was suitably informed on the fate of his appeal. We did this department's letter number so and so so. From the above discussion, it is revealed that the extension of suspension of Sridhar from time to time has been made with strict adherence to the extant rules and as per recommendations of the review committee. In view of the above, I am directed to request you to reconsider the decision of the ministry regarding revocation of suspension of Sridhar with effect from 4th of June 2021 and confirm the stand of the state government in this regard.
You are not concerned with this.
No, this communication I sent it to the state government saying to the central government saying that you please your stand, my lord, possibly is not correct. You take the stand. But subsequently, this has been diluted when I have already passed an order revoking the order of suspension.
Yes. Yes.
That has been diluted because subsequently this order was passed. This is a communication of 25th of March 2022.
No, is it a fact that you are continuing with the suspension from
No,
time
no,
to
no.
time?
That, my lord, I was continuing with the suspension, but after this order,
appeal was preferred.
After this revocation order, the suspension goes.
So now, when he has been allowed to join?
Well, he has been joined. He has been allowed to join immediately after this revocation of suspension order. And this was placed before the learned tribunal. The learned tribunal, my lord, observed that both the parties agreed and submit the suspension order has been revoked. And to that effect, an order dated 9 June 2022 has been brought on record. We both of us agreed that a suspension of our order has been revoked. I am not agreed by that part of the order.
So your contention is, as per the rules, what the authorities will do with the period of suspension is a matter to be considered after
the conclusion
disciplinary proceeding is
concluded.
over.
And that was my
you cannot, in terms of the rules, this what will be the status of that period cannot be decided at this stage, and as such question of further consideration on the basis of regularization does not arise.
No.
This is your
Well, my contention was that I have placed a specific order saying that I have revoked the order of suspension, and there is specifically stated therein that the period of suspension shall be decided after conclusion of the learned tribunal accepted that part of the order but modified the other part. Page 90 accepted that part of the order, is hereby pleased to revoke the order of suspension of Sri Debashish Dhar with effect from 14 June. But with regard to the other part, it has been modified by the learned tribunal by dint of this order.
And that modification is bad in view of the rules of 5B2.
5B 1 and 2.
Yes, Mr. Mujumdar.
5B 1 and 6, my lord, subject to correction.
But normally, in terms of section 16 of the General Process Act, a person competent to suspend is also competent to revoke unless specified by rules. That's section 16 of the General Process Act.
Yes.
But I showed to your lordship page 102 only for the purpose of satisfying your lordship's kind conscience, the unequivocal acceptance of the state government of the fact that it is not competent to suspend.
That is why they have revoked.
They have revoked. If I am not competent to suspend, then it goes back to the period of regularization. The regularization should relate back to the date of suspension. And that's why the CAT directed this.
Then how do you come across the regards of 5B2?
Not 5B has two parts. 5B cannot be read divorced from Rule 3. Rule 3 clothes the appropriate government to suspend. 5B is a special provision dealing with revocation. So the interplay of these two rules will lead to an inevitable conclusion.
Which two rules?
Rule 3 and Rule 5B. Now I shall place those two particular provisions.
Yes.
An authority competent to place a person under suspension may not be an authority competent to revoke his suspension. Please see Rule 3 and Rule 5B now.
The authority is state government. It has to be approved through the central.
Whenever it requires the approval, the final authority becomes some other body.
That is what has been
Yes,
done.
please see now page 92.
So you are meaning to say that there will be no suspension.
Unless approved.
Yes, there will be no suspension unless approved.
But whenever approval is not granted, it relates back to the date of original order. Meaning thereby it never existed. So in this case, the suspension order never existed beyond 30 days.
Yes.
Now please see Rule 3 at page 92. 91, I'm sorry.
তার মানে যেটা যে অর্ডারটা
Sustainability of suspense. সেটা প্রমাণিত ওই আর্গুমেন্টটা তুই ফ্রি টু ডু এট দি টাইম অফ ফাইন্যান্স যে তুমি আমাকে সাসপেন্ডেড ধরতেই পারো। ওর কথা হচ্ছে যে তুমি এই রেগুলারাইজটা করো, করে একটা অর্ডার পাস করে দাও। ট্রাইব্যুনাল বলে দিচ্ছে যে তুমি রেগুলারাইজ করো। ওর আর্গুমেন্টটা যদি অ্যাকসেপ্ট করে থাকে, কোথাও রেকর্ডেড নেই সেটা। অন দি কন্ট্রারি both of them consulted. ও নিজে it is a point of law, not we decided. যে whether without approval of the senator, which is mandatorily before, he at all was not found. Should is
suspension order. So এটা না was suffered by virtue of that suspension order is to be made good or it must be restituted.
রেস্টিটিউশনের প্রশ্ন তো আসবে, রেস্টিটিউশনের প্রশ্ন তো আর্গুমেন্ট হয় না। ট্রাইব্যুনালের অর্ডারটা কি ট্রাইব্যুনাল শুনলো না, ডিসকাস করলো না, দিল।
কিন্তু ও ঘুরিয়ে ওই সাসপেনশন করা টিল ফর নো একটা রাইট করতে চাইছে to decide further whether the period was spent on duty.
Exactly.
You want to reserve a right to consider later on whether the period spent on duty or
ন্যাচারালি সেটা তো আর্গুমেন্টই হবে। Yes, Mr. Majumdar.
Please see page 91, which is part of the All India Services Discipline and Appeal Rules. Suspension. Down below that, page 3. If having regard to the circumstances in any case where articles of charge have been drawn up, the nature of the charges, the government of a state or the central government, as the case may be, is satisfied that it is necessary or desirable to place the suspension of a member of the service against whom disciplinary proceedings are contemplated or are pending, that government may.
That is state government.
I will come to that later. So the first and foremost is suspension of a member of the All India Service is contemplated where charges have been drawn up.
Regard to the circumstances in any case.
Where articles of charge have been drawn up.
And if having regard to the
and where. So,
circumstances in any case.
So it's conjoint.
And where it's a very good.
And where charge have been drawn up. The nature of charges, the government of a state or the central government. Come to it later on. But not the first and foremost is two conditions have to be satisfied. One, a charge has been drawn up and regard to the facts and circumstances of a case.
Very good.
may place under suspension against whom disciplinary proceedings are contemplated or are pending, that government may, if the member of the service is serving under that government, pass an order placing under suspension.
Yes.
Not when the order of revocation of suspension relates back to 4/6/2021, charge had not been drawn up.
When was the charge drawn up?
The first charge sheet was dated 11th of June 2021.
It is pertaining to June 2021.
11th June 2021.
And the other one?
The other one is September, 16th September 2021.
Yes.
Now kindly recollect the date of revocation of suspension related back to 4th June 2021.
That is
revocation order.
Past, that is
page 80.
Page 8.
Or page 89, whichever way your lordships look into it.
No, page 89 is the state government, no?
Yes, and not page 80 is the ministry's decision, the Ministry of Home Affairs, central government.
In neither the charge sheet was nor the suspension was confirmed. Suspension. So rule 3.1 you are placing.
My lord. So the moment the state government accepts the finality of the central government's decision that the suspension order should be revoked from 4th June 2021, there was no charge sheet. On that date.
So this is an issue to be decided at the time.
Now please see, if that is not so, how can the tribunal's order be said to be flawed? For this.
Flawed because it is juxtaposed to rule 5B2.
5B would only come when one is placed under suspension.
We understand.
I come to 5B1 later on. Not
Mr. Mojumdar, we are at the interim stage.
Correct. So not at the interim stage.
What you're wanting is that you revocation of the suspension. I was not at all suspended. It should be taken as that.
Therefore,
the proceeding must fail suspended.
No. Proceeding I am contesting. Proceeding I am contesting.
But that issue, Mr. Mojumdar, is to be delivered upon by the tribunal.
Correct. Now, not so far as
today,
so far as suspension is concerned, that issue is closed by the tribunal. The parties have accepted.
The parties have accepted revocation done.
Right.
Now, benefits of that revocation you are asking him to give. He's
No. I'm not on that. I am on today. We are only on those 30 days.
Yes, 30 days. What regularization you want? You have been suspended. You have brought back. Whether even if disciplinary proceeding they hold against you.
Correct.
That period, whether it will be treated as break-in service or not, that is not an issue to be considered.
I am not at all on break-in service.
Then what on you are on?
5th May 2021 is the order of suspension.
5th May 20. Yes.
4th June 2021, the suspension is revoked.
Yes.
11th June 2021 is the first charge sheet.
So there could not have been any suspension at all in your case.
That's why the tribunal directed regularize this period. Number 1. Number 2, please see 5B1 now. The authority competent to place a member of the service under suspension is different from revoking of suspension. Please see page 92.
Yes.
Your Lordship has been pleased to find that if he is a member serving under the state government is to place under suspension. That's the coinage of words, place under suspension.
That is state government here.
Please see, no, we are on the different aspect. Please see the second proviso to C. Provided also that whereas state government passes an order placing under suspension a member of the service against whom disciplinary proceedings are contemplated, such an order shall not be valid unless before expiry of a period of 30 days from the date from which the member is placed under suspension, or such further period not exceeding 30 days as may be specified by the central government for reasons to be recorded in writing. Either disciplinary proceedings are initiated against him or the order of suspension is confirmed by the central government. We pause here for a moment. So after 30 days, the central government did not confirm. Now please turn over to 5D now. At page 94. Now this is probably part of. No, please see page 94. Not I just showed your Lordship not two expressions used at page 94. This is part of rule 3(1)(d). 1 capital D.
1 capital D.
Clause 6 capital A.
At which page you are saying?
And I'm placing page 94.
94 starts with the line conviction if in
Yes,
the
yes.
matter con-
Please come down to 6A, clause 6A.
6A.
Yes. Where an order of suspension is made or deemed to have been made by the government of a state under this rule. So now it is taking care of a particular situation where a state government has made an order of suspension. Detailed report of the case shall be forwarded to the central government within a period of 15 days of the date on which the member of the service is suspended or is deemed to have been suspended, as the case may be. An order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified or revoked by the authority competent to do so. So here comes not the expression authority competent to revoke. It is quite different from an authority competent to place a member under suspension, which is different from a competent or authority who is competent to revoke the suspension.
Yes.
Now please see the clause B. Where a member of a service.
Revocation will be by the authority competent to do so. Now,
In this case, the central government.
Revocation is the central government. But in this case, as the central government permission was not sought for, central government said that goes.
Not the clear expression used in 3 is, it shall not take effect beyond 30 days, because that's why the timeline. 15 days you file a detailed report, 30 days is the outer limit. It has an injunctive language. Please see rule, the proviso at page 92. It's an injunctive provision. Provided also that where a state government passes an order placing under suspension a member of the service against whom disciplinary proceedings are contemplated,
unless it is approved within 30
such an order shall not be valid unless approved.
Right, right.
So it's a clear embargo. Please juxtapose this to page 94. Within 15 days, the government is supposed to file a detailed report to the authority, and the authority competent to revoke the suspension has revoked. So the person or the authority competent to place a member of the service is different from a person from the authority competent to revoke in this case, as per the special requirement of the rules. Now please see B. Where a member at 94.
Yes.
Where a member of the service is suspended or is deemed to have been suspended, whether in connection with any disciplinary proceeding or otherwise, and any other disciplinary proceeding is commenced against him during the continuance of that suspension, the authority competent to place him under suspension may, for reasons to be recorded in writing, direct that member of service shall continue to be under suspension subject to sub-rule 8. So this is only a special provision, which once again,
Mr. Majumdar, why we are going into this?
because I say that
Today your suspension has been revoked, good, bad, indifferent. Revoked. Your argument is that there was that suspension contrary to rules because you did not issue the charge sheet by them.
therefore regularize.
You have to treat me to be in regular service. Continue. There was no element of very good. Suppose today that decision will inure some benefits to you. That decision, if your argument is accepted, then he will be treated as in service from the date of suspension.
Not, in any event, not a suspended employee is treated as in service.
In the practical sense of it, that he becomes entitled to all the benefits.
Correct. Not the moment the revocation was set aside, I became entitled.
Exactly. Now now kindly come to the rules. Rule 5B.
Yes. Now please see. So now see. Please,
Our
page 90.
query is, Mr. Majumdar,
Yes.
that this issue,
My lord.
why it has to be decided by us at this stage?
Because not my learned friend's client, being the state government, says that I have a right to not regularize.
No, we will not say that.
Please see page 98.
We will. His contention is that you are asking me to take a decision on an issue which has to be declared by the tribunal. Suppose this argument will be there on your part at the time of final hearing.
That's my point. I am not required to go before the tribunal, or not. The tribunal is not delving on this issue anymore. Not my challenge is thrown.
Mr. Majumdar, I think.
Please see page 98.
It is inextricably bound with that. The proceeding is one.
Normally, but for the special rules. Please see page 98.
Yes.
Admissibility of pay and allowances and treatment of service on reinstatement after suspension.
Yes.
That's the section heading. What is the date of suspension?
If May.
4th, no, reinstatement after suspension. 4th June 2021, I am reinstated.
Date of suspension.
5th May 2021. 4th June 2021, I am reinstated.
Yes.
Now, when a member of the service under suspension is reinstated, not reinstated should be probably has to be read as revoked. Suspension is revoked. Reinstated is.
No, that is 5B6.
Yes, I shall come to it. Not 5B6 is referable to 5B1 once again.
Yes.
When a member of the service under suspension is reinstated or would have been so reinstated but for his retirement. Suppose not a suspension order with a disciplinary proceeding has resulted in a court proceeding or exoneration, and I am reinstated in service. But there was a penalty of say termination and I am reinstated in service. While under suspended, superannuated while under suspension, the authority competent to order reinstatement shall consider and make a specific order. Who is the authority competent to make an order of reinstatement?
Tell us who, according to you, is the competent.
Now, if your lordship decides on the point of reinstatement after the disciplinary proceedings, then there are several rules in the CDA rules of the All India Service itself, which once again is reconcilable with rules of suspension. Central government, ultimate authority.
Why you are then preempting the decision?
No, I am not preempting. I say that tribunal has directed to regularize this 1 month period.
That regularization, you are saying question of regularization in fact does not appear. Your argument is that you have to treat me as on service from the date I was suspended, because the entire backlog proceedings were without jurisdiction.
No, I don't. I am challenging the proceedings on different grounds.
No, not the proceedings, the suspension. What you are wanting us to decide today, you are asking the state government to regularize that period.
But why state government? Please see 99. I say
regularization is not required because suspension itself goes.
Now this 30 days period. We are on this 30 days period. We are on this 30 days period only now. 5/5/2021 to 4/6/2021.
Yes.
Now please see 99.
Page 99.
5B3.
5B3. Yes.
Where the authority competent to order reinstatement is of the opinion that the suspension was wholly unjustified, the member of the service shall, subject to the provisions of Sub-Rule 8, be paid the full pay and allowances to which he would have been entitled had he not been suspended, subject to adjustment in respect of subsistence allowance and other allowances already paid. So that's after conclusion of proceedings. Now that is a completely different scenario altogether. Now see 5B5. In case other than those falling under sub-rules 2 and 3, the member of the service shall, subject to the provisions of sub-rules 8 and 9, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been suspended, as the authority competent to order reinstatement may determine. It's not the authority competent to place under suspension.
Yes.
And the rules make a quite distinction between the authority competent to place under suspension and the authority competent to order reinstatement. After giving notice to the member of the service of the quantum of proposed so and so, now 5B6, where suspension is revoked pending finalization of the disciplinary proceeding or proceedings in a court, any order passed under sub-rule 1 before the conclusion of the proceedings against the member of the service, that's my learned friend's case,
Yes.
shall be reviewed on its own motion after the conclusion of the proceedings by the authority mentioned in sub-rule 1, who shall make an order in accordance with the provisions contained in sub-rule 3 or sub-rule 5 as the case may be. So note 1 is to be read with sub-rule 3 and 5, and that is why page 120.
120.
102.
102. The matter is in consider the state government extend করে তাই চিঠি দিয়ে বলতে চাইছে যে তুমি ওই রেশনটাকে তুলে নাও, তো একদম সাসপেন্ডেড আপনি অলরেডি দ্যাটস ইট। টেক রিকনসিডার দি ডিসিশন, মানে রিভোকেশনটা তুমি তুলে নাও।
Now this speaks of reviewing of an order of suspension. 5B6 is a specific provision for reviewing. This is non-existent in the facts of the case by reason of the competent authority directing revocation and the state government having accepted the same.
No, this will go. Question of reconsideration
Does not go. So not 5B6 will not apply here at all.
Yes, Mr. Anything else? Anything else?
So not when it says,
Or I come back on 3:15 minutes. When can you come back to? How long will you? Yes, how long will you take?
10-15 minutes at the most. No, I can come back to that. I don't want to detain your lordship. I got the.
Not for that, because we have to hear you in reply. Or we can come back at 2 p.m. if you are otherwise you come at 2 p.m. ফিক্স করে দিলাম কোনোদিন ফিক্সড আছে
আমার কোথায় আছে কি
Heard Mr. Siddiqui learned AGP appearing for the petitioners and Mr. Mojumdar learned advocate appearing for the respondent number 1. Is the matter for further consideration as for orders in the daily supplementary list of this court. বলে দাও না কোথায় থাকবে
সেকেন্ড বাদ দিয়ে 22 তারিখে
নেক্সট উইকে রাখছে না নেক্সট উইকে রাখতে কবে রাখছে 25 তারিখ তো অনেকগুলো ফিক্স আছে না 31 তাহলে 29 ফিক্সড আছে কিছু 30 একটু কম আছে অরিজিনাল স্যার সাথে করে সময় 3:15 তো হয়ে গেছে দুটোর সময় রেখে as for orders on 30th as fixed at 2 p.m. You will take 10 minutes. You will take 10 minutes. Pass out. Interesting point.
proceed. 17, my lord, I am for the petitioner. Lord,
For the respondent, my lord, with planet ASD. Today he is not
last
possible, my lord. He is engaged in another court.
Talk with him. We are really embarrassed. We are
Ne-
really embarrassed. Talk
Next
with him,
week, any
please.
day, my lord. Next day, any day fixed. Next day, what kitchen? Matter of next any.
So you should have talked with him. See, we are from the morning,
Yes,
we
my
are
lord.
embarrassed.
I think, my lord.
What is the matter about?
Lord, let my supplementary be taken record at first. Lord, issue is, your lordship will remember, the only one question of law, whether at the date of death or on the date of consideration. That's the only law point.
Compassionate appointment.
Yes.
Actually, third
Supreme
wife.
Court, my lord, has now laid down the law.
Which judgment you are referring?
Lord, this is the parent judgment, my lord, 2021 SSC online. It was again subsequently followed in Ahmednagar Mahanagar Palika versus.
Name whose judgment?
My lord, I am
Justice
following the
Nagaratna?
Secretary to the Government Department of Education versus Bhimesh alias Bhimappa.
Stop. Mr. Mukherjee, learned advocate appearing for the petitioners, files a supplementary affidavit. Stop. Let the same be kept on record. Stop. You served.
I already served.
Sir,
That is with them.
I received the.
Now, let them tell a specific date. My lord, on that date, your lordship will decide.
So we will wait for the date stated
My lord,
by the
otherwise, my lord, I am suffering. Last occasion, they took an adjournment. Today also, my lord.
Today an adjournment has been sought for on behalf of the respondent. Stop. As a last chance, the matter stands adjourned. Stop. Lease the matter for further consideration on এটা কবে থাকে recently? 2nd February দিয়ে Yes, 2nd
My lord,
February.
second, I will have some difficulty. It might be on third.
Second.
Second day একটু অন্য মান।
আজকে কি বার? বৃহস্পতিবার। 9th February করে। Yes.
Yes. কে?
18
না, 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 প্রধান রেকর্ড শহীদুল হক। হ্যাঁ, দিয়ে দিচ্ছি। একটা কাগজ দেন না। হ্যাঁ,
Item
শহীদুল হক, শহীদুল হক।
I appear on behalf of the petitioners.
আর আমার প্রতিপক্ষ।
My lord,
in 18 in this matter, I also led by Mr. SG Matter.
So you people don't.
Yes,
No, you juniors have do not go through the briefs.
yes, I go through.
Then
That's the further information.
Yes, Mr.
my lord, this matter relates to compassionate appointment on change of nomination. Change of nomination. My lord, after
The first time it is coming. Today it is the
no, on 8th instant
Last occasion is also.
took time on behalf of Mr. ASD.
I also appear on last occasion.
Then, sir, what we have to do? If in all matters without the ASD the matter cannot be heard, then we cannot proceed with anything. We cannot proceed with it. It is not possible also for you to appear in all the matters. That is why you are engaged.
Yes.
You will not take this opportunity to go through the brief.
I go through, man, but I have go through.
Then let him start. Who is you are engaged in this matter?
Yes, I am also engaged.
So why you are telling?
I said that I led by Mr. Larned.
No, led by means he is there in this matter. He is there in this matter.
Last occasion he also not appear.
Last occasion we did not find. Who is appearing, sir?
I appear on last occasion with ASD. Last occasion he also not appear. That's why matter was adjourned.
On 8th instant, one Mr. Subroto Satra, London, yes, he appeared and he took time on behalf of Mr. ASG, London ASG. Change of nomination rejected in 2005.
No tarik na. Do tarik na. Second paper. If he comes very good, otherwise
Yes, I'll.
if he is busy, you get ready, you are. Yes.
I appear on behalf of the state, Your Lordship.
Your name is there.
The petitioner, my lord.
Yes,
For last occasion, your lords, the original order which passed by the authority was not annexed, my lord. My lord, I have annexed, my lord, to order of the authorities, my lord. First, my lord,
Have you given copy?
I have served.
Yes, Your Lordship.
Yes. Tell us what is the matter.
My lord, what happened in this matter, my lord, kindly see the order of the Honorable Tribunal, my lord. Last order, my lord. It is, my lord, second time, my lord. I have come before this Honorable High Court, and also second time, my lord, I move before the Honorable Tribunal, my lord. So this is, my lord, first, last order, my lord. I am coming, my lord, first order. My lord,
Which order you are placing? 20th July.
20.
Yes.
Last page, my lord. Order.
15th December 2022, Your Lordship. Resignation then, Nick. You're not resignated, no?
Yes.
Yes, my lord, the last page, my lord, for order, my lord. The tribunal also fails to be satisfied of the appellant's applicant's economic condition, warning such an employment. The appointment on compassionate ground is very specific with regard to the economic condition of the applicant and his family at the death of the employee. By the very word compensation, the state extends such assistance in the form of employment if it is of opinion that due to the sudden death of the government employee, his family has been left high and dry financially. In view of the observation, the tribunal does not find any merits in the matter and this application is disposed of. Well, earlier order, my lord, earlier order I challenged before this honorable tribunal, my lord. Kindly come to page, my lord, page 23. Have you got it? Page 23, my lord. Well, I'm
22.
reading, my lord. Page
20.
23. Earlier tribunal order, past order.
23.
23.
Yes.
This order was passed by this honorable tribunal when my representation was not considered and rejected. Then I challenged before the honorable tribunal. Tribunal passed this order by set aside the order of the authority, my lord.
What was that order first? First order by
First order, my lord, passed by the authority, my lord, rejected my application.
What is that order?
Well, that order I have submitted, my lord, annexed
Let us
to the
go
supplementary
serially.
affidavit.
Let us go serially. Where is that first order?
But a supplementary affidavit I have
Yes, yes.
annexed, my lord.
Your father died due to an accident. Died due to an accident.
Died in
Died in an accident.
accident.
What was his age?
Well, date was father 4/11/2001. Yes. When my mother applied in time, well, I have annexed my lord documents, my lord. Well, everything has been discussed on first order of the honorable tribunal.
Yes.
Details have been
Let
discussed.
us go through this part.
My lord, your lordship.
First order টা কোথায়?
First order, my lord, 3rd April 2018. Last page, my lord, of the supplementary. And first order, my lord.
First order was, you said this 9th.
Well, first order, my lord, 3rd April 2018, which I have been rejected, my lord, when I applied for.
Page.
Email not here. Email not.
First order by which your application was rejected. What is the date of that order?
Date of the application, my date of the rejection, my lord, 3rd April 2018.
Very.
Last page, my lord. Well, kindly excuse me, my lord, page is not done, my lord. Why, my lord?
Yes.
Yes, my lord, page 23. My lord, when the
Have read. Yes.
my lord,
23.
the 23, my lord, I'm reading, my lord.
Yes.
But the superintendent of police Howrah directed Manoj Bagh through the concerned police station, my lord, page 23, paragraph, second paragraph, my lord. To appear, police Howrah directed police Manoj Bagh, petitioner hearing, my lord, through the concerned police station to appear before him with relevant testimonials on 28/6/2011. Subsequently, OC Kolakhat police station, having been directed by the police authorities, submit his inquiry report regarding financial condition of Manoj Bagh. In the report, OC categorically states that he conducted the inquiry personally and the financial source of the family is only the late of father's pensions of rupees 5,500 per month and some small immovable assets. Finally, a proposal for compassionate appointment to the Manoj Bagh was disposed of by the Home and Field Affairs Department, memo number such and such, by rejecting the application on the following grounds. My lord, page 24, my lord, second para, my lord. From the record submitted, it is clear that after the death of Sushil Kumar Bagh, the mother applied within the time for providing compassionate appointment to her son. Manoj Bagh, upon attending majority, Manoj Bagh, upon attending majority, also submitted pro forma application. Thereafter, the police authorities conducted written test, interview to the test his capabilities for employment under the police department. However, no result of such a test has been intimated.
Have you got the rules, Mr. Ghosh? Have you got the rules? 2015 rules?
Your Lordship, 2016 rules herein, Your Lordship. The 2016 rules, Your Lordship, specifically. This is the 2016 rules, Your Lordship.
On the basis of which it was
Yes, Your Lordship. It says.
After clear, my lord, kindly. Kindly.
Yes, yes. Please, place your.
My lord, it is surprising that after a lapse of 6 years from the written test and interview, the state respondent rejected the application without giving any specific reason as to why the application for compassionate appointment is being rejected. The order communication by the Deputy Secretary to the Director General and Inspector General of Police, West Bengal, that dated 3rd April 2080, only quotes that the required conditions were not fulfilled to make him eligibility for employment under exempted category. The order of rejection concerning the compassionate employment of Manoj Bagh lacks sufficient clarity and is against natural justice. The order is quashed and set aside. And my lord, against that, my lord, order, my lord, the petitioner challenged before this honorable court for getting a direct appointment, my lord. The honorable high court also affirmed this affidavit, this order, my lord. Page, my lord, 25. Before this honorable court,
High Court did not set aside the order.
no, my lord, only there is no affirmation into the order sheet, my lord. Affirm this order, my lord. There is no gross violation of the any order. So they further directed the authority to consider the issue. Then, my lord, the authority disposed the representation of the petitioner further My lord, I have annexed, my lord, the authority, my lord, further order in the supplementary affidavit, which was not annexed earlier in the repeat.
You did not annex that in the main petition.
That was not annexed in the petition, my lord. You will also giving liberty to annex and file a supplementary affidavit.
Page 4.
Page 4.
No, no. Page
No, no,
4
one
is
first
the
order,
affidavit.
first order, my lord. Annex ये करे नहीं करना, page net करे नहीं जैसे
6A, your lordship, page 6A.
6.
The typed copy.
Page 6.
Yes, Mr. Ghosh.
Yes, my lord. Page 30, my lord.
Yes.
When I challenge before this honorable court, my lord, the honorable tribunal, my lord, admitted the my case, my lord, before the honorable state administrative tribunal. Page 30.
I could send it again to the authorities to consider.
Consider. Not interfering into the matter.
High Court made an observation that why he was called for written test and interview. High Court ultimately sent it back. And now the authorities have rejected your case on the basis of clause 10
Underage.
double A. Double A provides that if you come within 5 years, then also we will consider. But Mr. Ghosh, here it is more than.
Well, I am coming, my lord. I show you judgment decision of the Honorable Supreme Court.
Yes.
Supreme Court already considered the case, similar case.
Soyyad Khadim.
Well, I am coming, my lord. Soyyad Khadim.
Soyyad Khadim has been distinguished.
Well, para, my lord.
ওই প্যারা থাকবে না বলছে that is not, that is under 142.
Yes. Page 6, my lord, already.
You know that judgment.
Yes. Reported judgment. Well, another, my lord, unreported judgment also, my lord. Division bench judgment, your lordship coordinate bench. Tania Islam versus coordinate bench, my lord. Another coordinate bench, your lordship coordinate bench also accepted the.
Sir. Copy. Judgment realize what you have.
Yes, Mr.
Yes, my lord, division bench, your coordinate bench, your lordship also pass the order, my lord. In favor of the একটা আছে তো আর নেই
একটা এটা আগে দিয়েছে আচ্ছা তানিয়া ইসলাম
অন্য কিছু
Yes, which paragraph?
or last paragraph.
After this, the scheme came, Mr.
Yes,
Mr. Ghosh.
yes. After
Do you have the scheme? Please
no,
go through.
victim, that is my lord. My lord, my father already accident death, my lord.
Pardon?
Father, my lord, accident death, and after that, my lord, here, my lord, tribunal what said, my lord, what have been stated, my lord. Family is under starvation, my lord. My lord, report of the committee, my lord, officer in charge, my lord, inquired the matter, my lord. There he filed the report. Family is under starvation, my lord. It has been mentioned in the order sheet of the Honorable Tribunal, earlier order, my lord. Everything has been discussed.
No, this, where is the rule, 2013 rule? This is an amendment you are showing.
Yes, Your Lordship.
Please show the main rule.
Main rule, 2013 rule, Your Lordship. Right at this moment, I don't have the 2013 rule with me, Your Lordship. I shall come.
Self-belated request can be considered under the new.
Yes, Your Lordship. I shall come back with the 13 rule. I do not have the 13 rule right now, Your Lordship. In that event, Your Lordship will kindly see the existing rule 2013. The one, two, the third column, Your Lordship. 7 of the notification. It assigns 6 months, Your Lordship. হ্যাঁ আমি একে বলিনি
Which one? Acha, Mr. Ghosh, you finished there.
Yes, Your Lordship.
Another coordinate bench also judgment is unreported.
Mr. Ghosh, what? Thou.
It is also unreported judgment, my lord. Here also case also consider, my lord, underage. When the mother already applied in time, there, my lord, the last order, my lord, the Honorable Court directed the authority give him appointment, either his mother. When you have not given any appointment, you should consider the case of the petitioner, my lord. This is unreported judgment, my lord. Last page, my lord. Only. Would the unreported judgment consider an authority? They have given the appointment, my lord.
This unreported judgment was on the basis of Sayyid Khadim. This which you are referring to. Sayyid Khadim was taken into consideration. Second matter also Sayyid Khadim was taken into consideration. Yes. But now the High Court has considered that and said that Sayyid Khadim is 142. It will not be a binding precedent.
Judgment.
That I am showing you the judge. That's it.
Second one submission before your lordship. But second submission before your lordship, when the matter was more challenging the authority last order. Last order, my lord, challenging when the my lord before the honorable tribunal, my lord, I challenge before the challenge tribunal, my lord, order of the rejection. Second rejection, the honorable tribunal admitted the case, my lord, case 32. when I moved before the honorable tribunal admitted my application, my lord. Next day, my lord, also, my lord, the direction was given to the respondent to file affidavit. Without affidavit, my lord, without hearing, order passed.
Mr. Ghosh, your
This is my
case-
submission.
Uh-huh.
This is my submission.
We understand. Yes, what do you say?
Your Lordship will kindly see 2013. It's the chart I have provided, Your Lordship. That is a comparison of the 2013 regulation in comparison to the 2016 amendment, Your Lordship. Your Lordship will kindly come to the second page, Your Lordship, where note C under para 6, the second column. 2013 earmarked that the dependent member shall have to invariably attain the minimum age of recruitment.
Nine. 2009.
2019, 19.
Volume
Volume 1.
1.
CHN 614.
6-1.
Please go through this judgment and come back and tell us how can we help you.
All right.
কলকাতায় ঠিক যাওয়ার আগে
Hello, what
অরিন্দম চৌধুরী ভার্সেস স্টেট অফ ওয়েস্ট বেঙ্গল। Yes, what years?
Yes, Your Lordship. Your Lordship, 2013 regulation earmarks that a dependent member shall invariably have to attain the minimum age of recruitment within. Your Lordship, second page of the regulation, Your Lordship, the second column. Your Lordship, note C under para 6C. The dependent member shall invariably attain the minimum age of recruitment within 6 months from the date of death or incapacitation of the concerned employee. Your Lordship, this was deleted, and in 2016, the time limit or the belated request was enhanced, Your Lordship, where it says, Your Lordship, 1, 2, 3, the fifth row, Your Lordship, belated request in exceptional cases such as death during action when none in family is eligible, etc. Departments can consider request for compassionate appointment even where the death or retirement on medical ground of the government servant took place up to 5 years ago.
Exceptional cases such as one.
Yes, Your Lordship.
Death
During action.
Death during action, what does it mean?
Death during action, for example, Your Lordship, on duty, if the person dies on duty. Or the second option is where none in family is eligible, which is applicable for in his case. But in that also, the servant has to take place up to 5 years. The age limit is 5 years. Your Lordship, in this case also, it is not the case of the petitioner that at the time of the death, the Wife of the deceased had applied for compassionate appointment.
Intent.
So,
No, Your Lordship.
wife applied for the minor son.
Wife expressed that.
But tell us, how do you, this date was in 2001.
Your Lordship, he applied in 2011.
When did you attain majority?
Your Lordship, 2010. He applied at the age of 19.
Age of, no, when did he attain majority?
Yes, Your Lordship. He was 11 at the age in
date
201.
2001. That time this circular was not effective. When the
Your Lordship, it is well settled that
died in the year 2001.
Your Lordship, this is well settled that
the
the
circular has been, my lord, effected, my lord, 2000.
Okay. 16.
16.
Your Lordship, it is in 2000.
2019 he attained majority.
19. 19. No. 9.
What is the
1,
date
2,
of birth
3,
of
11,
the
12, 13, 14, 15, 16, 17, 18, 19. 2008, Your Lordship. He attained the age of 18 at the age of 2008. In 2001, he was 11. So,
his father died in 2011.
11, Your Lordship. Sorry, I'm so sorry. 2001, Your Lordship.
2001.
2001.
That time, my lord, circulars was not effective.
He was, his father,
We have heard you. Let him
Yes.
his father died in 2001.
Oh.
He attained the age of 18 in 2018. 8.
2010 he
It was a
applied.
8, 9. He applied in 2010.
On the date of death, he was 11.
11.
So he attained majority after 7 years.
7 years.
So in 2008, he attained majority.
And he applied for compassionate appointment in 2010.
2010 he applied.
10.
A circular has come.
Now 2010, prior to that, come to page 22.
22, Your Lordship.
Prior to that, you considered him, asked him to appear in an interview. And
Yes, Your Lordship. His parameters were considered, Your Lordship, but considering his yes, Your Lordship, considering his candidature, Your Lordship, does not give him a right to be appointed in as a under compassionate appointment.
How does he come? His case was rejected by the
In 2018. Initially his case was rejected on 2018.
We are not talking about initial rejection. We are talking about the last rejection. Where is that? We have annexed.
Last rejection order is of 2022.
Now kindly come to 2022 order.
2022 order, Your Lordship.
Yes. Where is that?
Lordship, page 6A.
You have applied the circular of 2016.
Page 15. Yes.
Yes, Your Lordship.
2016.
Yes, Your Lordship.
The 2016 circular was amended.
Yes, Your Lordship.
Original comprehensive scheme was 3rd of December 2013. That was the initial, that was the scheme.
Yes, Your Lordship.
And he attained majority. His application was made
2010, Your Lordship.
2010. Then how does he come under this scheme?
Your Lordship kindly considers, Your Lordship, it is a well settled principle of law, Your Lordship. I shall come back with the judgments as well if Your Lordship requires. The rules which will apply, the rules as on the date of consideration shall apply while consideration of an application and not on the date of application, Your Lordship. Your Lordship, his candidature was considered.
Where is that reason given by you in the order?
Your Lordship, it is clearly stated that the rules shall be applicable, and in terms of these rules that.
Person applied in 2010 according to you.
Yes, Your
The
Lordship.
rule has admittedly come in 2013. So as what judgment you are showing that it will be from the date of consideration?
Consideration of him. Your Lordship, I shall come back with it. Kindly gives me a day's time or 2 days' time. I shall come back with the judgments, Your Lordship. And Your Lordship will also consider. Your Lordship will.
That his application was 2010.
Yes, Your Lordship.
On that date, he was major.
Yes, Your Lordship.
So, on
But
the
there was
date
a.
of consideration, even if you rely upon the scheme, he has applied within the time limit.
No, Your Lordship. From 5 years from the date of decease of the employee, Your Lordship. The belated the regulation is.
To us that the 2013 scheme is applicable in the instance.
Grateful, Your Lordship. And also, I shall show your Lordship judgments where the Supreme where the Supreme Court clearly indicates.
Date of consideration.
Your Lordship, I shall also indicate Supreme Court judgments where the compassionate.
There is no installment hearing given. You ought to have been ready with your judgment. When you find
Your Lordship, my apologies, Your Lordship. I shall kindly keeps it tomorrow. I shall come back with the judgments, Your Lordship. Sorry, Your Lordship. Next week. Any day next week, Your Lordship, I shall come back with the judgments. কি বলছো আপনি কপি দিয়ে দেবো আপনি ডেট ফিক্স করুন
volume 2019 volume 1 CHM page
614
হ্যাঁ 24
Lordship, I shall bring the judgment, but I shall also indicate the citation, Your Lordship.
All right.
24.
The learned advocates appearing for the respective parties have concluded their arguments. Publish the matter as per orders in the daily supplementary list of this court on 24th.
Your Lordship, Your Lordship, one judgment I shall indicate, Your Lordship, also 2023, 2023, 3 SCC 773, Your Lordship. It clearly says considering. Sorry, Your Lordship.
2023.
Volume 3 SCC 773. I'm so sorry, extremely sorry, Your Lordship. It clearly indicates, after considering all the judgments, that the rule that is prevalent at the time of consideration.
By yourself thereafter.
Great, Your Lordship.
Why 24th? What problem you have?
No, one matter, my lord.
25th is
25th.
25th. 25th, any problem?
Grateful, Your Lordship.
আমাকে এটা এটা কাজ করতে
না না তুমি পড়বে চল্লিশ বছর অলরেডি চাকরি পেয়ে গেছে এইটাকে
For total positive petition, 20 বসে বসে ওইটার নিচে আর একটা পরামর্শ আছে
তুই ইয়ে কার্তিক
Loser matters, my lord. They are supposed to give a report of who has been given appointment and why. If not, why not? Eight petitioners.
একটা কপি দেবে দেখছি স্যার আসলে দুটো কপি আছে অরিজিনাল কপি
Yes, Mr.
may I submit what formal report has not come to me however by chairman of railway board they have prepared a chart showing there are 8 petitioners. Out of 8 6 have got already appointment and so far two petitioners are concerned, they have preferred a review applications. We
No,
said
that
so
review is
that
not
you
there.
withdraw the review or let the review proceedings is over.
Yes, I have shown him. I have given him the copy also. He's forgotten that.
And now the next step is the document verifications. If review is over, then they will be called for document verifications. After document,
You have given the copy to me.
Yes, yes, I have sent him the copy.
Do you have that instruction whether they have been called?
no, as on date, they are. I think so, they have not called up.
No, no, they have not been called.
Yes, review because after verification of the documents, they will be called up to appear in paid.
No. What is your instruction? That review chapter is over.
No, so review over.
Review
over.
Review chapter is over. Now you have to call them for document
Verifications. The next step to appear before the paid. Yes.
So why you have this was last heard on 6th of December 2020.
Yes, they're in the process. Right? Kindly accommodate us 2 weeks times. In the meantime, I think so documents will be verified, and when I also record these things, may I submit this status report? It will be for 2 judges. Last 2 জন বলি
Have you checked up?
No,
They have been given.
No, 6, what he has said is correct.
6 which already appointed. Already appointed? Already appointed 6.
Mr. Nundi London, appearing for respondents.
We have issued appointment letter. One kindly record that.
Submits, upon instruction, that
Bera.
who are those petitioners, Mr. Nundi?
But 1 to 6.
1 to 6.
Serially.
The petitioner numbers 1 to 6 have already been appointed. Have already been appointed.
I stand correct. So far my list is concerned, I am addressing 1 to 6. I am referring from my status report. 3 to 8. So far read petitions.
1 and 2 have not been given. 3 to 8 have been given.
That is petitioner numbers 3 to 8 have already been appointed. They have joined.
No, we have issued appointment letter, but that I am not updated whether they have joined.
They have already been issued letters of appointment.
Lordship.
Such fact has not been disputed by Mr. Samanto, learned advocate appearing for chief. petitioners. The other time is subjects upon discussion that appointment letters have been issued. Petitioner number 3 to 8 have already been. Petitioner numbers NOS stop 3 to 8 have already been issued letters of appointment. Stop. Let the এখান থেকে such fact, next further, such fact has not been disputed by Mr. Hon'ble, learned advocate, appealing for this. He, however, submits that though the review application filed before the learned tribunal has already been disposed of by an order dated 13th of October 2022, no steps have yet been taken by the respondents disposed of on the petitioner numbers 1 and 2 have not yet been called for document verification or physical efficiency test.
Sure,
Mr. Nondi, we can record that they will be called for.
Yes, as per the proceeding.
Mr. Nondi submits that steps are being taken by the respondents. Mr. Nondi prays for a short accommodation so that in the meantime appropriate steps can be taken by the respondents. Appropriate steps can be taken by the respondents. Somebody prays for a short accommodation. No, Mr. Nondi submits that the petitioner number 1 and 2 Mr. Nondi submits that the petitioner numbers 1 submits that the respondents are taking necessary steps and the petitioner numbers 1 and 2 would be called for document verification soon. Stop. Shortly. Stop. In view thereof, list the matter for further consideration in the daily supplementary list of this court on 20th of February. Stop. On the returnable date, the chairman, railway recruitment board shall file a report as regards the follow-up steps taken by the authorities in respect of the petitioner numbers 1 and
grateful. I'm grateful.
Nondi, we keep it on 23rd February. See, in the meantime, document verification and date is over. That will be better. 23rd.
23rd February.
23rd, intimate them so that in the
Meantime, the 2-stage is over. Yes. Now we are showing more bona fideness that
you are showing, not your person.
Not your clients. Grateful. At least they kept my words and they are being serious. Character. Actually, the civil level put a dispose of
instruction দিয়েছে let the বন্ধু প্রথমে বললো না upon instruction
সব কোয়ালিফাইড লেখা আছে কোয়ালিফাইড লেখা আছে if you qualified you have to qualify
submission let the document as produced be kept on record. ওটা দেখে দিন। Yes, next.
Item number 21.
In 21, my lord, the appointment was given. So this petition has become infectious. Yes.
Mr. Samanto learned petitioner or petitioner?
Petitioner. One.
Mr. Samanto learned advocate
এতগুলো ক্লায়েন্টের চাকরি হলো মিষ্টি তো খাওয়ালেন
Mr. Samanta, learned advocate appearing for the petitioner submits that during pendency of the present writ petition, the petitioner has already been
we have issued appointment letter.
Issued the letter of appointment. Stop. As the grievance of the petitioner stands repressed, next paragraph. As the grievance of the petitioner stands repressed, no further order is required to be passed in the present writ petition, and the same is accordingly disposed of.
I'm great. Good. No, sorry.
আচ্ছা একটা লাইন অ্যাড করে দাও। We appreciate assistance extended to this court by Mr. Nandi, learned advocate.
With Mr. Sawanto, so because fine.
সামন্ত নয়, সাতরা। তুমি আমার নাম দিয়ে দিলে তো হয়ে গেল।
Assistance extended to this court by Mr. Samanto and by Mr. Satra, learned advocate.
Mr. Nondi and Mr. Satra.
Mr. Nondi and Mr.
Grateful.
Satra.
I'm deeply obliged.
We thought Mr. Samanto is on both the sides.
I'm grateful. It's only because of your lordship's orders that they had to do it. I'm grateful.
Mr. Samanto, 90 about it is my limited knowledge. I have seen many state advocates and opposing advocates when we cannot challenge so much. Usually the advocates help. That is the dignity of our bar.
That's right. Yes, that's right.
Our duty is not to oppose everywhere. All cause.
That exactly was the system.
That is cause the advocacy.
And that is because of conscience.
Conscience and advocacy.
I can share an
but yet not affirmed, Lordship, because the petitioner is not well. So I am praying for you. Kindly keep this matter after 29th January, Lordship.
We are for the respondent, Your Lordship.
You are Miss. You are Miss.
They. Means they.
Is they learned advocate appearing for the petitioner is for extension of time to file the supplementary evidence. Let's say supplementary evidence will be filed within 2 weeks with copies to the learned advocate within 2 weeks with copy to the learned advocate appearing for the copies করে দাও copies to the learned advocate একটাই respondent.
Respondent. No.
You are at all.
Yes, sir. Union of Name.
With what is your name?
Rashmi Bhutta.
Huh?
Rashmi Bhutta.
With a copy to you are on record.
Yes.
With a copy to the advocate appearing for the is the matter for further consideration. 3 weeks. Yes.
We appear for the respondent.
Lord, I appear for the petitioner. Lord, matter pertains to, my lord, the dual charges allowance, my lord, was not calculated at the time of, my lord, revising the pension of the petitioner. Petitioner retired, my lord, in the year of 1997 from the post of Deputy Chief Personnel Officer. And he held, while in service, my lord, 2 posts. One is, my lord, Deputy CPO within bracket RP, and second post Deputy CPO within bracket IR, GRC. That is the additional post. My lord, after retirement.
Since when? He was retired in 97.
97. My lord, that is for the period.
Tell us the matter, then what happened?
Yes, I am submitting. My lord, for the 2 posts, my lord, the after retirement
in 97.
Basic pension was fixed. That is at, my lord, your lordship may kindly have a look at page 34, wherein the revised basic superannuation pension is fixed at the rate of rupees 6,000.
Page 34.
Page 34.
Yes.
6,000.
Where is 6,000?
My lord. First, second, third. In supersession of the Office Pension Payment Authority number quoted above, I am to forward here with revised 6,000 basic pension. Thereafter, my lord.
No, this was revised basic pension.
Yes.
When you retired, you got something else.
That is, my lord. Yes.
So very good. Then what happened?
That is page 33. That has been pension is there. This is my PPO.
Very good. Then what happened?
My lord. Thereafter, my lord, they have issued the this order memorandum, that is 7th August 1998, page 38, wherein it has been admitted that payment of dual charge allowance is therefore admissible in favor of Sri D. Haldar, Deputy CPO, for the above period from so and so. Page 38. Sri Dhanurdhar Haldar, Deputy CPO, was detailed to look after the duties of the post of so-and-so in addition to his own by the competent authority by office order dated so-and-so. Sri Haldar performed the full duties of the post of Deputy CPO IR from 96 to so-and-so date without any break. FA has accorded his concurrence wide letter number so-and-so dated 31st July 1998 for drawal of dual charge allowance for the above mentioned period.
So this was found to be admissible.
Yes.
This was not given.
Yes.
This was given.
The very next page, my lord. Your lordship may kindly have a look. Page 39. Very next page. And they have admitted.
Hmm.
Page 39.
Yes.
In supersession of this office pension payment authority number so and so, I am to forward herewith revised authority to grant revised basic superannuation pension in favor of Dhanurdhar Haldar at the rate of rupees 6097. That is 97 is the dual charges allowance.
Yes.
Thereafter, my lord, your lordship may kindly have a look, page 41. It was further revised.
Yes.
And in addition to rupees 56 being the increment, it has been fixed at the rate of rupees 6153.
Very good. 615.
My lord.
Page 41.
Page 41, first 6153. 6097 plus 56, that is the increment. These are all admissible.
Very good. Now, when did the problem?
Problem is, my lord,
Yes.
at the time of revising at the 6th CPC, the dual charges allowance was not reckoned. 6 Central Pay Commission revising my pension, dual charges allowance was not, my lord, calculated.
Dual charges allowance was that 97.
While refixation of pension, 97. Yes, 97.
That is page which you showed us. That for that period it is admissible.
Yes, this is admissible that I have been given the pension considering calculating the dual charges allowance. Pension has been fixed. This is admissible, admitted. In my pension, dual charges allowance was calculated.
That is page, you showed us page 40. No.
Page that is
Page 38.
page 39. Grateful to your lordship.
39 that this 97 was pertaining to dual charges allowance. Where do we find that?
My lord, they have admitted in their reply.
This is with dual charge.
They are not denying this.
Now, 6th pay commission was given effect to from when?
2006.
1/1/2006. You are saying that you have not been given the revised
While revising my pension, dual charges allowance was not calculated at the time of fixation of pension, revising the pension. 6 CPC. 6 CPC.
So you made representation most probably.
Well, that I will show before you. Yes. Various representations.
Now that was rejected.
Yes.
Then show the rejection order,
My lord.
which you challenged before the trial.
Order of rejection is page 75.
Page 75.
My lord.
19th of March. 19th of May.
My lord. 8/10/2018.
Order of rejection.
But before entering into the order of rejection, how I am entitled, 2-3 lines.
You will argue, let us understand.
My lord.
Where is that order of rejection?
Page 75. Internal page 50.
Page 75. To us, which on which ground it was rejected? This 8th of October 2018 was the subject matter of the original application. That was not. Original application
No.
wanted setting aside of 16th of May 2013.
Yes.
11th of November 2015. Then 8th of April. Very good. Yes.
8/10 is there.
Yes.
কনফারেন্স চার্জ আগেও দেওয়া হয়েছিল
দেওয়া হয়েছিল পিরিয়ডটার জন্য। Yes.
Well, herein it has been said that on retirement your pension was fixed as per the extent provision in vogue in that material time, while it is a fact that para 650. I'm reading thereafter. Before that, my lord, I'm showing my lord RB এটা কত RB এটা, but I'm showing that RB, my lord, RB 11 of 2013, that is at page 58. Your lordship, straight away come to the chart at page 59.
We will go to that. Sure, the tribunal rejection. Why tribunal did not interfere with this order? Then you are
Tribunal rejection, tribunal, my lord, that is tribunal rejection is not, that is the page, it is not paginated. Last order.
Internal page 5. But you be wrong. Which is the wrong?
Page page 9.
Page 9. Yes.
Applicant is primarily aggrieved with the refixation of his pension at the rate of rupees 14,960 per month on the basis of 50% of minimum of the scale of rupees 15,600 to 39,100, and that whiteboard's letter number dated 11/2013, the dual charge allowance element of rupees 97 has been discontinued. According to his claim, A12 of the way he should be granted so and so, so and so. It has not been granted by the tribunal. That is my claim. And I will show before your lordship, RB.
It has been rejected on the ground that you, on the date of your retirement, you were not executing such dual work. Their contention is you have been given that during the period you work. That does not come within your pay, basic pay, which is revised. After
Grateful.
revision, it is.
I am grateful to your lordship. That does not come within my basic pay. This is the additional.
This is additional.
Yes.
That is which you have been given for the period you work.
Yes.
And that expired after subsequent thereto when you continued and retired. On the date of retirement, you were not holding any dual duty.
Yes.
Kindly come to 650. That is the ground. Now RB 11 is quoted here. Let us see RB 11. Read RB 11.
Yes, I am reading. My lord, your lordship, the date of retirement is 31st March 1997, and pension has been started 1st April 1997. 31st March 1997. And my lord, they have admitted the dual charges allowance and they have given.
That is for the period from 12th of June 96 to 30th July 96.
Yes, that has been.
To return.
Right. But when that has been given? Immediately after my retirement.
Maybe.
Yes. This, my lord.
Not immediately. You were approved by this letter of 7th of August 1998. That is, your retirement was on 31st of March 97. Kindly come to page 38. This admissible benefit was given to you. Question is that whether that will come within the zone of consideration when your pay scale will be revised.
Yes, whether subsequently, question is whether subsequently at the time of revising that would be revised or not.
That has been denied by them on the ground. Page 75. Kindly come to their reasoning. Page 75, clause 3.
Yes.
On retirement, your pension was such and such. Now, while it is a fact that 650 railway station, the additional pay, presumptive pay in respect of combination of appointments to be reckoned as pay and will be given to for the purpose of pension and post-retirement benefits. Your case does not come within such consideration because you are not holding the post on. This is the reason. And you are saying kindly see RBE 11.
Well, nowhere it has been said that the pension, while it has been fixed at the time of calculated at the time of granting pension and subsequently it would be revised. This is not the ground. Their ground is that while revising my pension, it is included in my pension. They are not denying. They are saying that dual charges allowance is included within 14,960. 14,960 is the revised pension in terms of my lord 6 CPC.
Where they have said? Where they have said?
My lord, they are replying.
No, no.
Reply টা।
না না এটা তুমি করো প্রথমে ওটা এডিট করতে পারি যেন তখন তো ডুয়েল চার্জেসটা স্যাংশন হয়। ডুয়েল চার্জটা স্যাংশন হয়েছে রিটায়ারমেন্টের পরে 98 গিয়ে স্যাংশন। Kindly come to internal page 9 of the order. Please let us understand what the tribunal said.
Yes.
Tribunal, it is an admitted that on such and such, he was no longer now. RB 11 says it has been decided pension of pre-2006 pensioners. Pre-2006, that is he comes. Pensions as revised with effect from ATO in terms of 4.1 as amended would be further stepped up to 50% of the sum of minimum pay in
That is the how the pension is calculated. That is the method of calculation of pension at the time of revising.
And the great pay coordinator from which the institution as arrived at with reference to fitment tables annexed finance department. It's a very good. Mr. How you are aggrieved then?
Dual charges allowance has not been included in my pension.
So the reason, what do you say about the reasoning given? Additional pay, presumpting pay in respect of combination of amounts to be reckoned as pay as defined and will count for the purpose of pension and other post-retirement benefits. So yours is a special allowance.
My lord, your lordship, kindly have a look. Page 4, internal page 4. Paragraph 4. Paragraph 4(2). Paragraph 4(1). That consequent upon the retirement, the applicant's pension amounting to rupees 6153 was fixed as per extant rule 5th CPC, which duly took into account the dual charge allowance in calculation of last 10 months average pay. Second, the pension of the applicant 6153 was revised to rupees 13,908 in terms of corresponding revision chart circulated under RBE number so and so, and such revision inherently contained the dual charges allowance. So they are giving, they are saying that it inherently contains.
Then what you have not been given, suppose it is included.
Yes, I'm submitting. Lord, in terms of CPC, my pension has been revised twice. One, Lord, 1/1/2006, and thereafter 24th September 2012. While revising in 24th September in terms of RB 11 of 2013, it has not been revised. Excluding the dual charges allowance, they have revised. It ought to have been included inherently, but they did not do so. Why? I am saying, your lordship, kindly have a look. I am explaining, my lord, it is, and apart from this argument, if, my lord, I consider in that event, their argument, my lord, the railway service pension rules, rule 90 attracts.
Was what is the wrong in the order? You are coming after 3 stages. Tribunal, we are in sitting in judicial review. Unless you can show any error apparent on the face, we shall not interfere. You show us that what is the error apparent. You are saying, if we have understood that what are the admitted facts? Admitted facts are on the date of retirement, you were not having a dual charge. And the other fact you are pointing out is that dual charge was taken into consideration by them.
My lord, one thing right now I cannot clarify, that is whether after considering the dual charges allowance, my lord, the time gap from the retirement to till 1998, whether the arrears have been given or not, they can say. If the arrears has been given, considering the dual charges allowance, then I have been granted, my lord, immediately after retirement.
What is your stand, Ms. Alam?
Lordship, this is a new point that he is raising now,
No, no.
Lordship. Regarding arrears.
These dual charges.
Lordship, dual charges was given. Dual charge was given, but the dual charge, if your lordship says, was for a particular period while in service.
Right.
So that component has been taken into account. Had he been holding a dual charge on the date of retirement, then that would, then what my learned friend is trying to say.
It is your statement that we have taken that.
We have taken it. We have taken it.
Kindly come to what is your
Lordship and my reply. Yes. Lordship, I think
page 4, internal page 4 of the order.
in the internal page, the respondents per contra would rebut the claim. Consequent upon his retirement, applicant's pension amounting to rupees so-and-so was fixed as per extant rules in the Fifth Pay Commission, which duly took into account the dual charge. That is right, which duly took in charge because he had worked for a certain amount of time, and that was taken into account. The pension of the applicant of rupees 6.53 was revised to rupees 13,908 in terms of corresponding revision chart, circulated under RB.
Contains dual charge.
It contained dual charge.
Then what is his grievance?
That is what I don't, because what he wants probably is holding both posts, a continuing dual charge, the post as well as the dual post. Lordship, that
this is pension.
Pension to be commuted that way. Lordship, what he worked, Lordship, what he has discharged, we have given.
কনফারেন্স চার্জ অর্থাৎ 10% বেশি যদি কাজে দিয়ে at one time. No, এখানে বলছি that would not be calculated in your case. No. কিন্তু তাহলে ওরা বলছে কি করে যেটা আমরা সেই রুলটা করতে যে যদি কেউ তার সার্ভিস টেনিওরে ফর এ পার্টিকুলার পিরিয়ড যদি সে অ্যাডিশনাল ডিউটি ডিসচার্জ করে তাহলে তার পেনশনের স্কেলে সেটা অ্যাড হবে ওরাই তো মেনে নিচ্ছে সেটাই তো মেনে নেওয়াটাই অ্যাকচুয়ালি মানে এই যে অ্যাভারেজটা বার করে লাস্ট 10 মান্থ অ্যাভারেজ পে লাস্ট 10 মান্থ অ্যাভারেজ পে স্কেলে ঘুরছে কি তাহলে লাস্ট 10
if you have already included it, we are not being able to appreciate. We understand your logic that that was prior to retirement specified period. We have given, my brother is saying, so we have
He's
given
been paid that amount, yes.
you have
That is
paid
the
that
allowance.
amount, then why that payment you are including in the pay scale for the purpose of fitment and for granting pensionary benefit?
That has not been done.
Lordship,
Am I?
Lordship, let me seek further instruction because Lordship, because that is what because it has been included and then it has been revised, keeping that component in.
It's kept and revised, then there is no
There
problem.
is no problem,
Then
Lordship.
why this chapter is coming that you are not holding?
That is for my learned friend to answer.
No, that your officer has said in this order. Page 75, your officer says.
Page,
page
yes,
75.
that rejection of his.
Kindly read clause 3. On retirement, your pension was fixed as per the extent provisions invoked at the material time.
Yes.
While it is a fact that VDA para 650, the additional pay, presumptive pay, payable in respect of combination of appointments is to be reckoned as pay and will be given for the purpose of pension and other post-retirement benefits. Your case does not merit for such consideration, since you are holding an additional post on the date.
You were not holding. Lordship, we will have to see what he asked for. What was his demand, Lordship? Because that is not here. Whether he wanted, Lordship, you had to look after the duties.
No, Miss Alam.
Yes, Lordship.
What does 650 say? That the additional or presumptive pay will be reckoned as pay and will be given for the purpose of pension.
Yes. And that
now your case does not merit for such consideration due to such reason.
Lordship, let us read it again.
Your case, since you were not holding any additional post on the date of your retirement on superannuation. Got that line, Miss Alam?
Lordship, paragraph 3, right?
Yes.
And the additional presumptive other post, your case does not merit such consideration. On retirement, your pension, Lordship.
Yeah, let us stop here for a moment.
Yes, Lordship, I wanted to see what he applied for.
No, our query is that you are on one hand you are saying
that you are
that it can be reckoned as pay, but I will not consider you since you were not holding that post.
It seems that we have also done.
Yeah,
it is already done, and then he's enjoying that. It is already done.
Then show us
Lordship, let me find out what he applied for at that point of time. Otherwise,
come within 10 average 10 months.
Then I shall ask whether I can, because
while revising 14,960 at that point of time, excluding the dual charges allowance.
Miss Alam, I think your competence, your officer, these are all intricacies of pay fixation. It is very difficult to get hold of, because one who is not thorough with the departmental rules is not possible.
That is.
So you please inquire this fact and tell us that what was his fitment, how the pay was given, how does such fitment is supported by your order. If the pay is, if it is included, then it is paid.
It is paid.
Then he has been given the revision on the basis of that.
Yes.
Then nothing remains.
Nothing remains, Lordship.
No, it has not been included.
But it has been, Lordship. That is.
Also have to explain your stand to us.
It is not been, because it will be fine. It has been.
I shall try my level best, my lord.
Only for 3,
yes, 96 and.
But one simple thing is there.
At that point of time, there was no.
11, 20, 13.
Last 10 months হয়ে যাচ্ছে বলে ওটা ইয়েতে স্কেলে বেনিফিট তো পান। এবার ইয়েটা হচ্ছে পে কমিশন অনুযায়ী যার পেনশন ছিল 10 টাকা, সে সিট কমিশন অনুযায়ী তার 15 টাকা, এইভাবে হবে। Why you have again change? Cannot change.
চেঞ্জ তো করেনি,
ওটা বাদ দিয়ে দিয়েছে।
বাদ তো দেয়নি। ওরা বলছে যে আমরা এভিডেভিটে তো বলছে আমরা ঢুকিয়ে দিয়েছি।
Inherently, ঢোকায়নি. Inherently, they are saying that while revising,
That has been taken into
that
consideration.
component
dual charges amount has also been revised. They are saying this. But second revision in terms of 6 CBC,
Then what is your grievance then?
But in terms of second revision, that is on with effect from 24th September.
If the fifth pay commission was giving you the benefit,
Yes.
then automatically you will be
Sixth
given
is getting
the
the
sixth
same.
pay commission.
Yes.
So then your client must have got that.
No, I'll show your lordship. That I'll show your lordship that my client has not got it. That
Which
I'll show.
document? Which
Lord
document?
11/2013, my lord.
11/2013.
11/2013. Your lordship
11?
2013. My lord, may I come back other day?
কত পাতাটা কত লেটেস্ট?
Lordship,
Which is, my lord, that is page 59. That is the pay fixation. I will have to explain everything. My lord,
You first get explained from your client.
I am explaining, my lord.
Page 59 বললেন না?
Lord, first of all, I submit the
Third, the learned appearing for the respective parties list the matter as per orders in the daily supplementary service report on 6th February.
6th February.
Grateful to lordship.
6th February.
If you can prepare a chart to that effect,
I shall.
that is